জিতেছি ওরা আপিল করেছে, স্টেট গভর্নমেন্ট আপিল করেছে, বুঝতে পারেন?
Yes, may I leave your permission mentioning one matter? The state of West Bengal preferred an appeal along with the Expedition Section 5 petition. Matter is pending for a long time. I am for the writ petitioner. Winners in the writ petitioner.
Where is your notice?
Notice has already been served.
Where? That you are
Today you will mention. Today you will mention.
I witnessed.
You given a notice intimating that today you will mention.
Please give a notice and come back and tell us.
Yes.
May I have your lordship's kind leave to mention this matter for extension of the interim order? Lordship, I'm mentioning upon notice. Lordship had earlier extended the order. It's expiring on by the end of January, Lordship.
Who is your other side? What appellate side matter?
Lordship, appellate side matter.
Is it in the list?
Lordship, it had went out of the list for a while, Lordship.
Why you did not appear?
Lordship, Lordship, I was given the liberty to mention the matter by your Lordship's order, dated 20th December 2024.
First. Yes. Have you filed your substitution application?
Lordship, I have just been instructed. I have not filed the substitution application yet, Lordship.
Then how it can be, how there is no interim order?
Lordship sees the earlier order that was passed on 18th November 2024.
Substitution application.
Lordship, I have just been instructed it has not been filed yet, Lordship.
So it cannot be extended then. It is defective, no?
Yeah, appeal is defective now.
If you file the substitution, we can take it on record and thereafter we can extend, right?
There is a time you file.
You immediately file an application for substitution and mention before.
I'll do that, Lordship. Grateful, Lordship.
May I, my lord, be permitted to mention an assigned matter before my lords, my lord? I am mentioning upon notice. It is, my lord, running as serial number 117 of the monthly list, my lord. My lord, this is the appeal, my lord, of 2015, my lord. I am the successful auction purchaser, my lord. Possession has not yet been handed over to me, my lord. Recently, it has been assigned to my lord. So I was humbly beseeching my lords, if my lord's convenience permits, kindly, my lord, let it be taken up as a daily list matter, my lord. Any day, my lord, subject to your lordships.
2015 matter.
My lord, it has been specially assigned, my lord.
Maybe.
My lord,
But your turn.
my lord, the
Your notice had already been served.
Sorry, sir. It is in the list. Wait.
I'm on behalf of the bank, respondent bank.
That matter.
that
Remind us after the combined list comes up. Let us see how it can be. Not much of it. Yes. Call the list.
Hello, may I permit one application? Connect the mail of the
Notice you have given.
I have served my immediate services. There is no
No application.
new application, my lord. For manual appeal. Group 1, man.
আরেকবার বললে হবে না।
Group 1.
Which year notice? Which year matter?
2024, my lord. 25. Answers, my lord. The group 1, my lord, appeal, my lord. It is the order of the, my lord. Fresh matter, my lord. Fresh matter, my lord.
Total Kartik. Notice থাকবে না fresh matter.
Fresh matter, my lord.
Yes, call the What you are saying?
Notice served.
Show us the notice that you are mentioning today. একই জিনিস বলছি। Have you given notice that you are mentioning? This is a letter you are writing to your other side advocate. This is of 19th of June. Give a notice that you will mention the matter and then come and mention. Yes, call the list.
mention
can grant me leave to file an appeal without certified copy. The matter is very extremely urgent. Without service of notice, an order of demolition order has been passed by Justice Rai.
Demolition order passed.
Demolition of an unauthorized structure.
You were not party to the
I'm a party. Notice has not been served.
notice was not served.
No, my lord. I have checked the FTO service, it dispatch. But before that order,
When was the order passed?
order passed, we came to know from the PWD authority, order passed on December 2024, 12 December, 5th December.
When did you apply for certified copy?
My lord, I have annexed this counterpart.
Yes, leave granted.
I'm grateful to you, Lord.
Yes, call.
My lord, may I be permitted to mention, my lord, 3 assigned matters, my lord, contempt. Those were directed to be listed today, my lord. So far, my knowledge goes, my lord, but it has not been listed.
It will be listed, Mr.
My lord, grateful, your lords. And
Can you
another,
give the details of
my lord, I am giving this slip, my lord. I am giving this slip. And one assigned matter, your lordship heard the matter in court number 32 that has been assigned before your lordship. That my lord, I am giving the slip of the
that you have to mention upon notice.
my lord,
So
my
what
lord.
is the content?
That I will mention upon notice, my lord. Grateful, your lords.
Yes, call the list.
But I appear for the National Medical Commission.
My lord, I beg to for the applicant, my lord. One indulgence, my lord, Mr. Shamim will be appearing in this matter. He's, if your lordship kindly fixes up this matter on Monday, my lord.
Monday.
On Monday, my lord.
Monday, it is a review. Monday, this bench will not be there.
Then any day as your lordship's day.
So you are now newly engaged.
Not, my lord, just for the adjournment, for seeking for an adjournment, my lord.
Then it will be on Friday.
This Friday, my lord.
If you do not,
Monday, he is in difficulty.
Yes, my lord.
Monday,
Monday, I'm.
it will come on Friday. Let us, this is
Whenever
not
also this is from.
continuing for much time. Let him appear and finish it.
Yes. This review is an appeal in disguise that we can show from the grounds, Madam.
From Monday,
Re-agitating
my
all the
order will
points,
be there, no? So it is a review of our order.
Yes.
So it has to be heard by us. তো শুক্রবার দিনকে রেখে দিও and please understand this thing that if you don't do it on Monday,
Yes,
the
right.
question of you will not be able to get a chance till the end of Friday.
No, no.
Yes, all the list. Sorry. তাহলে এটা
10 and 11 are my appeals, Madam, which were dismissed for default yesterday. Lord, in these matters,
where is Dr. Koron?
Where is Dr. Kaur? He has just
yes, Mr.
Yes.
Dr. Karan is there. Lord, pursuant to Lord, earlier benches directions, Lord, not directions, Lord, liberty, but we had handed over Lord, our tentative calculation chart with regard to Lord, the direct purchase and the Right to Fair Compensation Act 2013. Now, my lord, my humble prayer in this appeal, my lord, is that the single judge has directed that to pay the compensation in terms of the Right to Fair Compensation Act, my lord, 2013. So, my lord, the window, my lord, for direct purchase may kindly be opened, my lord. My lord, it is not that, my lord, that price is negotiable between the parties, my lord. But if the window is closed, my lord, then, my lord, we cannot proceed in that line at all. And, my lord, coordinate benches have allowed us to proceed in terms of, my lord, the direct purchase policy.
Bandhavadhyay, that right does not take away the right of the petitioner to apply for initiation of acquisition proceedings under the Act.
Ultimately, they may not agree to direct purchase.
Show us any provision that this proceeding can be stopped and a person can be asked to make.
I am not, my the point that their right 2013 Act has to go.
But Mr. Bandhavadhyay, you're not.
But
taking enough
the
money.
collateral right, collateral liberty
But
may be
the
given
amount
to.
which has been
No, that is absolute.
invested-
If you logic kindly sees, we have mentioned that it is absolutely tentative and direct.
Where is that?
Kindly sees a single sheet I have handed over, pursuant to the liberty granted by the erstwhile division bench, এরকম একটা single sheet হবে তো।
Division bench. Earlier division bench passed any order.
Yes, earlier division bench granted us liberty to give a comparative chart.
That may have been verbal. There is no recorded order.
Where is the letter dated 10th February 2015 by the subdivision officer Gosaba?
My lord. এটা তো এটা স্টেপলটা খুলে দুটো একসঙ্গে করা আছে।
My lord.
What is that? Oh, that table.
Yes, my.
Oh.
In February
Well, 2nd February 2013.
2015. That letter was directed six respondent to act in terms of such and such date.
That letter perhaps is not part of the.
that letter is not here, Mr. Dr. Koro.
My lord.
That letter of
Not in our stay. Not in our stay.
Which letter, my lord?
10th February 2015.
Yes, yes. In the writ application, my lord, they have not annexed the writ application. Kindly, my lord, come to the writ application.
writ application file test.
Is it with you? Show us.
Please show us.
Sheet
that
একটু দেখাতে।
letter.
Yes, my lord. Yes, my lord. I am showing.
So, Mr. Banerjee, where is the provision? Can we force them?
So,
Agree to
ultimately they may not agree. Ultimately,
Letter dated? Letter dated?
10th February 2015.
10th February 2015.
যেটা single judge order record করা আছে। Now, my lord, I am only beseeching your lordship, my lord, to keep my window open, my lord, because it's a direct purchase policy. We may match the price also. We may match the price also, but if the window is not there, my lord, that we will be proceeding, my lord, in contempt of this order.
They are informing that my no land acquisition proceeding is started in respect of my land.
proposal. Executive.
So whether that can be a rider when they have admitted that they have utilized my land. But previous to that, annexer kindly see. My lord, kindly see the previous annexer, 2014 annexer.
পরেরটা কি রেস্টোর হয়ে গেছে? আগের দিন রেস্টোর করে দিল না? Before Raji passes the order, a coordinate bench's order, my lord, if I may.
Yes.
But
My
for
lord,
persuasive value, my lord,
extremely sorry that I could not bring that judgment. Where the Honorable Supreme Court, my lord, decided that when there is no provision, state has not formulated any provision or policy with reference to the Central Act, then court
has discretion to direct the state to make provision. My lord, if you lordship kindly, my lord, give time, my lord, I can bring that judgment.
No, how that will help you
Help means, my lord, my right is, my lord,
to get the land, to get the compensation.
my lord.
Now, the
But according to my humble submission prayer before you lordship, that I can agree to the direct purchase policy if I have been given the amount.
which you are not agreeing with this.
No, they are not agreeing to give.
This is tentative. This is not final. I am not being able to
8.20
impress this upon my learned friend.
8.20 according to 13 Act. Why I should not be given 8.8?
Right. I am saying that
8,20,000.
this amount may be given under direct purchase also.
My humble submission
But-
is that if they say that, yes, we will pay the money to direct purchase policy. So I can, they are agreeing that actually 2013 Act, they are not disagreeing or refusing. So I am entitled to the 2013 Act. So they have to pay that amount. What they are saying that 8,20,000 give me. I do agree to direct purchase
That
policy.
8,20,000, in the acquisition proceeding, if you have to wait for the award. Award will be on the basis of the market value of the land, etc., etc. By that you may be getting 100 rupees. Now they are saying that allow me to negotiate also, and it may so happen that 100 rupees can ultimately be paid to you.
Yes.
But we do not know this opening of window of negotiation. Dr. Karan, this award, this is a procedure which has to be followed. Your intent is to get the money, no?
No, they are saying the direct purchase policy. Let them submit the policy. What is the policy? Direct purchase
Policy is there in public domain. That is not a difficulty. It's not the case that policy is not there. Policy is there to 2016 policy. But here kindly see the objection of the learned advocate vehemently objected that my client should not be approached by the state.
My client?
My client should not be approached by the state. That was in the judgment I have handed over, 492, MAT 492. When the proposal was before the division bench, learned advocate stepped in to say that I am objecting to it. When the client was ready to approach
there is no order to that effect, my lord.
So you are not agreeing with 8.2 lakhs?
Yes, I am agreeing.
No. Malad, both are tentative. Malad, will kindly see the heading. Malad, we wanted to project.
Putting to their calculation.
কম হতে পারে, yes.
Direct policy তে 5.65.
Malad, may I put it in this way, Malad?
Compilation এটা কিসের
ওরা সেটা করে এনেছে
Malad, may I put it in this way? Malad, both the figures being tentative, it may so happen that 8.2 may be less, 8.2 may be 8 also, but 5.65 during negotiation may become 8.
that he's not agreeing, Mr. Bandyopadhyay.
Malad, if my window is open, Malad, my officers can approach the client, Malad, can approach the petitioner, but my window has been closed.
If that window is open, then the direction of the court to initiate acquisition proceeding would also get.
The intent of the court is that the land of the writ petitioner has been utilized, and he should be adequately compensated for that. Malad, the honorable court may have rightly directed that the acquisition should be under 2013 Act. But Malad, at the same time, since in our state another policy is prevalent, Malad, that window may kindly be kept open so that we can negotiate with the petitioner. The intent is not that you give it under 2013 Act. That is not the intent is give the compensation. I am only trying to add a mode to that payment of compensation.
In that case, the person agreed that I will take the money on the basis of a negotiation. In this case,
in that case, but there are others, Malad, where it has been allowed. But Malad, I can place those, but Malad, no harm will befall the petitioner if another mode is allowed to us.
Otherwise, suppose today ultimately upon computing the award you find that more than 5 lakhs something has to be given. It may come to say 7 lakhs.
Well, it may come to 10 lakhs also.
So we are proceeding on presumptions.
Yes.
Has passed an order that there is a subsisting issue. This may be considered. What is the wrong in this order? There is no wrong. We can 2 months time was given that we will consider. It will be 2 months from the date.
My lord, may I put it in this way, my lord? The Honorable Court missed that apart from the 2013 Act, another mode of purchase was available to the state. That mode may not be foreclosed merely because it was not opted for at that point of time of utilization of the land.
Of appeal here, that avenue will not be open in other cases. We are not saying it.
No, but in this case, but in these two cases, it will be closed. In these two cases, it will be closed.
Yes, take down.
Are you agree?
My lord, 8.2.
No, direct purchase policy.
My lord, no, my lord. If they my lord pay us 8.2 lakhs.
No, that they cannot say now. No?
Oh, okay, we are not. We do not agree in direct purchase policy.
Challenging the
প্রচুর পড়েছি মামলাটা করতে হবে ওরা তো 4 দিন একদিন
I appear for the respondent writ petitioner, my lord.
My lord, I'm for the appellant. Mr. Das is on his legs, praying for a short passover.
That Salt Lake property,
Salt Lake property allotment, my lord. Your lordship had given them extension to file their affidavit in reply.
they have given it. to
They
you.
have served it to me yesterday. We are ready. The matter it can be heard out, my lord. Very short point involved. In fact, Mr. Das already made his submissions on the previous day.
Not this week. Come in the next 30.
Lordship fixes a date, my lord. That will be retained in the field.
Pardon?
Lordship will fix a date and that it will be rare.
If it is to be fixed, then it will be on 12th week. It starts from 12.
Of February, my lord.
On
Otherwise, my
John-
lord, it will go down the list. Lordship fixes any date, my lord, and there will be retaining its position in the list under the same heading. Lordship passes an order, my lord.
An adjournment has been prayed for on behalf of the appellants.
My lord, I am for the appellant.
One difficulty, my lord, in spite of your lordship's last order, my lord, direction, my lord, though there was a section 5 application, but the copy of that, my lord, has not been served, my lord, to us.
Section 5 you have now served.
My lord, I have instructed my clerk to serve and I'm not.
For that.
I have the copy of the section 5 application. I'm giving it right now. There is only 63 days delay as per our calculation. My lord,
Not corrected the cost title also. Who had all added respondents were there? Who were there?
It's a removal of encroachment. My lord, the matter was initially, my lord, the single judge has passed an order in contempt proceeding. The direction was there to remove all the encroachers. They went up in appeal by filing a special leave petition. These all events, my lord, is of
My lord,
2015. My lord, they, in that appeal, my lord, filed by the the person, my lord, who seek to add as a party respondent in the my lord, appeal by special leave, the Honorable Division Bench said, very well, I am setting aside the order for the time being. You go back, you file an application for addition of party. Thereafter, the merit petition will be disposed of accordingly. Thereafter, my lord, they have been added as a party. My lord, all those illegal encroachers. My lord, this Honorable Court directed, my lord, the inspection to be done by the concerned BLLRO. 3 consecutive reports were being filed.
Let us hear it.
My lord, only problem.
Who are the added respondents?
The illegal encroachers.
Where do we find their names?
My lord,
There
I'm
are
guiding.
two appellants.
I'm trying to help my lord, but the fact remains I am being led by Mr. Joydeep Kaur, who is on his legs. So may I be permitted to have a short passover?
Now, how much indulgence do you want?
Oh, no, he's on his way. He's on his way. I've been.
Clear the defect first.
And the section 5 application, my lord, today.
You clear the defect first. You add them as party. There are very much party in the writ petition.
They are you are representing who?
Writ petitioner.
I am representing the encroachers. So
You are representing
the appellants are the encroachers, alleged encroachers.
There may be some other encroachers also who were directed to be impleaded. Where is the writ petition?
In the mandamus appeal, Lord, the application, they have to, Lord, annex the writ petition along with.
Yes.
Your name, writ petitioner's name?
Writ petitioner's name is my lord Lokhikanto Maiti.
6 to 40, how many? 6 to 40, 36 June. You are 32% before us. Where
Yes.
are the left 5? Rest 5?
My lord, what happened before the trial court is
They don't join TV, make them perform responding.
You have to make them pro forma respondents. Total applicant, respondents in the appeal. All how many? Yes, Mr. Cord. There has been no implement of the, as directed by the stamp reporter. Application for section 5 has not been given to him.
I have served
Though
the
the matter was heard on 7th of January 2025. Yesterday he came and mentioned that tomorrow they are reviewing. So you immediately enlist it.
Lord, the fact is that, Lord, they have been served with a notice that if they don't move out today, if they did not move out by yesterday, today they are going to remove.
We cannot injunct them, Mr. Cord, in the at the
Lord, only to the extent the land is not a government land. Lord, they are, Lord, under the Highways Act, they are invoking the powers. Lord, part of the land does not belong to the government, admittedly.
Which notice are you challenging?
Lord, your lordships may kindly, I have come up in appeal challenging an order passed by Justice Pottenaik, Lord, the learned trial judge, dated 29th April 2024. ঠিক আছে। সেকশন 5 কি খুব অপোজ করছিস চলে আমাকে কপি দেয় এখন দিলাম 65 দিনের মতন ডিলে আছে ওকে জিজ্ঞেস কর না ও তো সবই অপোজ
হাইওয়েজ একটা বের করো তো
That is the report of the DLN error.
Lord, the report is Lord, actually, Lord, we were not
been annexed.
we were not implemented as parties in the writ petition. The writ petition, the prayer was allowed, Lord, without hearing us.
Subject to correction, this is Lord, subject to correction by my senior friend, Lord. They have been added.
Listen to you. Just let us ascertain this demarcation report submitted by BLRO was on 20th March 2020.
We were implemented. Sorry, Lord, I stand corrected. We were initially we were not, but they were. Therefore, thereafter we were implemented. I stand corrected. Where is the report of the BLRO referred to here?
Report have you not annexed? Report.
No, my lord, I find that is not.
yes, my lord.
It was referred in the order in fume.
My lord, there is a supplementary affidavit which we have filed.
No, that is also not served to us.
সেটাও করেনি
I know the state.
I do not know.
Not the state.
I'm representing only, my lord, the writ petitioner.
Lord, the order itself, Lord, records that
It is 64 Act.
1962
62
Act, 1962 Act, Highways Act.
Highway Act. That means appeal was
Appeal has been preferred. Yes, we.
disposed of by the DM.
Lord, I tell you, Lordship, while this appeal was pending, Lord, the matter proceeded. While the appeal was pending, we have annexed, Lord, all the orders.
Well, the appeal proceeding is being challenged before the learned single judge. Today, the matter is appearing before courtroom number 14.
This order has
been given effect to.
Lord, we could not, Lord, obtain a stay because, Lord, the appeal was preferred out of time. In the meantime, Lord, the matter proceeded. But, Lord, what I want to show your Lordship is from the order itself. If your Lordships kindly come to the order of 29th April once,
Writ application was disposed of. No, it
Writ
is
app-
pending.
Disposed of.
Disposed of.
Writ petition
Then,
disposed of.
it is pending. Contempt is pending.
Contempt is pending. In the meantime, proceeding was drawn up. My lord, an order has been passed for removal of encroachment.
Lord, can I, my lord, have 5 minutes, my lord?
54 Act, 10-3 completed, 10-4 completed.
Thereafter challenging that a fresh writ petition is pending. Today appearing as item number 10 before courtroom number 8, before courtroom number 14.
করেছি।
My lord,
আমরা করেছি।
Yes.
তাহলে
Simultaneously, my lord, this cannot be.
File করেছো এই order টা challenge করে।
Lord, I did not know this fact. Lord, the main,
You withdraw the appeal and contest.
yeah, that is what has to be done. Your lordships may kindly take the order once. I tell your lordship what is our grievance. 29th April 2024, your lordship has seen that order. Please come to the second paragraph, which says that brief fact of the case is, has your lordship found that?
Yes.
That the petitioner is the absolute owner of land measuring 1.29 acres in RS plot number 521 of 685, IR plot number such and such. Now, my lord, the act has been applied also in respect of this property by the district magistrate and the corrector. My lord, here the admitted fact the petitioner came to court with, yes, this is what is recorded in the order, that he is claiming to be the owner of 1.29.
Portion, my lord, it's not an admitted fact, my lord, that it is.
Lord,
applied.
Please, Mr. Court, read the next line. The petitioner's land is watted and bounded on the western side by Namkhana. Next
Correct.
line.
Correct. May I just place it?
Yes.
Appertaining to RS Khatian number such and such, district such and such, it is contended that for the reasons of illegal construction of shop rooms and encroachment over the government land, the petitioner's egress and egress to his property has been affected. The petitioner made representation, etc. Lord, a private land, in respect of a private land, the Act of 1964 has been applied. Highways Act has been applied and eviction order has been passed.
Internal page 4, that
Yes.
submission.
Yes.
Internal page 4, second paragraph.
Yes, upon perusal of final demarcation report submitted by the Block Land and Land Reforms Officer Kagdeep, South Parganas, it is found there has been encroachment by the 38 numbers of encroacher on the PWAD lands adjacent to land. There are two parts of the land. Kindly take the.
So when this order was passed, you are in appeal against this order.
Yes, I am saying, Lord.
On the basis of the BLRO report, the DM has finished of the proceedings. This order has been implemented. Whatever ground you want to take, you take in the.
Lord, the point is that, Lord, a 64 Act can't be applied in respect of a private owned land. And where eviction order has been passed.
That the BLRO sketch map has to be ascertained.
Lord, the sketch map has been filed also before the DM. And that we have annexed. Your lordships may kindly, Lord, come to page 41 of the supplementary affidavit.
Lord, this supplementary affidavit is not being served to me.
তাহলে কি করে মামলা?
How can I, Lord,
How can
assist
you
the
tried
court?
your best, Mr. Court?
Lord, sorry, Lord, I'm really sorry.
Challenge, you have come to, really, you have challenged the order passed by the district magistrate in appeal under section.
Lord, kindly keep all the points open because, Lord, this unnecessarily, Lord, this point will be taken that an appeal was preferred and the.
No, he will withdraw.
You withdraw the appeal and.
Kindly keep all the points open because, Lord, the.
We are not saying anything. It is withdrawal. If you want us to say something, then.
No, I am saying that withdrawal, recording the fact that they have challenged the order before by a fresh writ petition. On that, Lord, kindly permit the withdrawal.
Then the matter is not ready, Mr. Kaur. How can we record that? Now we have to condone the delay, record the names, then pass an order. Na? Already it is defective.
Kindly do that, Lord, because.
Or we can keep this after 2 weeks. You try your luck.
Very well. Kindly do that. Kindly, I'm grateful. Kindly do that.
You will look like then you will go to the trial judge and say appeal is.
No. Lord, appeal is not in form because your lordship has not condoned the delay. So there is no question of saying that the appeal is pending. Section 5 has not been condoned by your lord. So, my lord, appeal has not been registered. It will have to be registered. It's not registered. So, therefore, there is no appeal in the eye of law as of today.
আমি জানতো লেখো মিস্টার advocate, who is the advocate on the learned advocate on record of the appellant?
Please, Lordship, I am but a petitioner, appointing me Subroto Basu, and you can.
Private respondent.
Private respondent. You are being respondent. So. Okay. Now, this is our application for sitting as an order passed by land tribunal. That it relates to Thika tenancy problem. The Thika Mr. Bose's plan, the respondent, they apply to Thika controller by saying it is a Thika land, the tenancy of Thika land, a bare land, and they have made construction. Thika controller rejected, dismissed. On merits held that no, it was not a letting out of bare land, it was land with structure, therefore dismissed. Now, appeal has been prepared in that similar DCC who has covered the appeal. Page 66, when that comes to see the memorandum. Then I shall, page 66. That's similar. 66.
The original applicants, respondents here, respondent number 6 to 9. They were the
6 to 9. Order.
Original applicants.
What is the application filed by Thika controller? They filed the application before Thika controller, but to see who has filed that appeal now. The application dismissed on merits. That is not a Thika land.
That order has been challenged by the...
Challenged by them before land tribunal. By whom? By whom?
Sons.
It is a firm with Khanna and Sons. It is unregistered. Admittedly unregistered, we show that unregistered. That's the only show me that who has prepared the appeal.
Mr. Mitra, where is Khanna and Sons in the cost title of this appeal? This
appeal page 66.
Khanna and Sons have not been implemented here. We do not find
How about in the writ petition?
petition.
Not implemented.
Anubhav Khanna, Kanok Khanna, Ankit Khanna, Torun Khanna. But the original applicants were Messrs. Khanna and Sons. Have you annexed the original application?
Yes.
Also not.
Khanna also not implemented here.
Yes, that's right. It's not because Khanna and Son has been dissolved. Being pending to the appeal, Khanna and Sons, when they filed the appeal,
The application which
yes, sir. That is the point taken, that therefore application should not be allowed. It is Khanna and Sons filed the appeal, claiming that the Thika land, Thika tenancy was there, the asset of partnership firm, not of individual partners. Appeal was filed by Khanna and Sons and one Arun Chandra Khanna. He's as a partner. That's why showing the cost that. At the time of admission appeal, the point was taken, the appeal was not maintainable. Learned judge passed an order, we were admitting it, keeping the question of maintainability open. Now, when they making an application, then during pendency of appeal, Arun Chandra Khanna died. Number 2 died. Mr. Khanna and Sons was admittedly comprised of only 2 partners. Arun Chandra Khanna and again application.
Torun Khanna.
Yes, Torun Khanna. And it is a so it became a
পিটিশনে ফাইট তরুণ খান্না নেই, তরুণ খান্না মারা গেছে। অরুণ খান্না মারা গেছে। অরুণ খান্না মারা গেছে।
দুজন
filed by the applicant for substitution.
Because 3 জন ছিল, 2 জন মারা গেছে। পেন্ডিং appeal 2 জন মারা গেছে।
লেয়ার্সকে ইয়ে করে দিল, দিয়ে আমরা এখান থেকে
Pending appeal. Yes. Number pending appeal, other partners died. Arun Chandra Khanna, then the remaining only partner remained Torun Chandra Khanna. So, upon death of Arun Chandra Khanna, the firm should automatically dissolve because we no longer 2 partners, only 1 partner. And that partner, Torun Chandra Khanna, is opposing that no, he is not a partnership asset. He opposed that. Because he got control also. He did not support this filing of the proceedings. So question arose, my lord, since the firm has automatically stood dissolved upon death of the second partner. There was Khanna died, and Khanna is the only partner. Then the firm has to dissolve. That's why the firm could not make a party. Use heirs of the dead parties. Now, this is partner heirs. And other made party, Torun Chandra Khanna, they have appeared, and they are opposing this, opposing the Arun Chandra Khanna. That's why my request lordship to see the memorandum appeal.
Mr. Mitra, you are challenging the order by which the substitution was allowed.
Yes, we are saying that appeal was not maintainable. And the learned tribunal decided, first decided question of maintainability to appeal, and then it was held to maintainable, then only he could hear the application for substitution. When the question of maintainability arises, and this appeal is admitted subject to question of maintainability, must see the order below. Appeal admission appeal order at page 110. Page 110. This is the page 110. Kindly come to. Similar, the appellants are is firm, and firm is that for the applicant, respond, etc. On being mentioned, matter is listed on today's list. So, Learned Counsel appears for respondent number 3 to 4 to present undertake to file vocal, etc. That portion may not omit that. Then admitted. Then applicants are directed to have copies of both. They see the last
Question of maintainability.
question really is kept open. So, we say when the appeal was filed, original this firm was Khanna and Sons, was admittedly unregistered partnership firm. So how could it file an appeal? That's the point raised. And that is now in course of hearing a pending of the appeal, another point arose that in pending of appeal, that unregistered firm to dissolve by operation of law because there are no two partners any longer. Only one partner, Torun Chandra Khanna, and he is not supporting this appeal.
That can be argued by you, Mr. Mitro. It has been fixed on 3rd of March. It has been fixed on 3rd of March. You take all points.
No, well, other March hearing, we are saying, setting aside that order of substitution. He has no jurisdiction to pass an order of substitution.
That point that
That point we have taken.
Mrs. Khanna stands dissolved.
If Khanna and Sons then dissolve,
Even if substitution is allowed, that does not mean the point of maintainability you won't be able to argue.
no, that is right. But substitution should not be allowed because in the appeal, what is appeal, the Rana tribunal had no jurisdiction any longer.
Maintainability kept open.
Yes, there were not. It is now more settled law. If a question of maintainability arises, then the court should have at least minimum prima facie hold that the proceedings are maintainable jurisdiction, and then decide the main application by pending. And in this interlocutory application, is that the tribunal recorded the facts which show that he has decided the appeal. In fact, he recorded, the finding is, bare land was let out. End of my case. So, may I cite one judgment to show that what the court should do? The judgment Supreme Court also, that when a question of maintainability or reason arises, court must decide that question of first, finally, or at this time of issue. Yes. That kindly similar.
Deciding here, but if such question arises,
My lord.
that anyone dies, and then the question of substitution come before the court, then keeping.
Yes, right. Well, correct. If there is no appeal, then no court of substitution in the appeal arises. That is the submission. That is the point you're taking. It's 65 Supreme Court, my lord.
The property is a right to a property, or right to enjoyment of a property.
Thika tenancy.
Right to enjoy a property.
Is the question whether this is Thika land or not. The only one partner, owing from the Khanna, he claimed that this Thika tenancy itself was part of the asset of the partnership firm. All other partners denied that. Partnership deed was produced, which do not mention this tenancy of this property at all. Thika controller found that what was let out was a land with structure. And therefore, whoever may be the owner of this tenancy, there is no Thika tenancy. And he dismissed the proceedings. Against the order, nobody else filed, no partners filed any appeal. Only Arun Chandra Khanna, he filed his appeal in the name of the partnership firm, Khanna and Sons, and making himself a second party as a partner. So it was appealed by a partnership firm which was admittedly not registered. Therefore, Section 69 of Partnership Act comes in the way. And we submitted all along that this is not maintainable. You kindly decide that point whether his proceedings or appeal is maintainable or not. And then it is barred by law. Then
where is the order of the controller?
Order of Thika controller, yes. Thika controller has dismissed the matter on merits. He has not decided on the question of maintainability. I'm giving lot.
Mr. Mitro,
Page 46.
we will make it clear that this substitution which has been made will not debar you from taking the point of maintainability before the tribunal when the matter is fixed on. Unless it is given, Mr. Mitro, the application itself becomes defective.
That's the saying. Whether those persons who have been sought to be added, they can at all appear in the appeal. That is the first question. They can at all appear in the appeal.
Can say the appeal will be proceeded in respect of a dead person.
Appeal, therefore.
If you accept your contention,
Yes, Mr.
that you decide the maintainability of the maintainability point path.
Yes.
Then substitute. then the court would be forced to proceed against one of the dead persons.
May I point out, may I point out one thing? Court will decide whether dead person can be substituted by his legal rights.
For substitution.
By substitution. Whether in this application for substitution made in a dead appeal, if I may say so, will be heard at all. Would be heard at all. Whether the court of jurisdiction to hear this application for substitution made in appeal, which already did, which was barred by law, which could not be heard by the court. Like 69 unregistered firm admittedly. That order also say that. That question has got to decide. But a proceeding for fine, which is barred by law, in the proceedings, involuntary applications are made. The court should first decide the question of barred by law or question of jurisdiction of the court. At least prima facie, that is the law laid down by our division bench and also the Supreme Court. Let this point be decided. Let this point be decided, and this point, the substitution or application order be kept in state. Point, let him decide the question of maintainability. And if it goes against the favor, I do not know. Whoever person agree will come to court.
Rightly or wrongly, as on dates, a substitution has already been done. Rightly or wrongly, by this order,
Yes,
it's not a challenge.
Yes.
I think it has been given effect. Here we are making this observation that this substitution will not affect your right or will not prevent you right to reach the maintainability point, and the tribunal will decide the same.
Decide the question first.
Yes.
Decide the question first, and will not give effect to substitution until deciding that question. That is the point. Whether that party can be added. A party can be added in a point which was not maintainable without jurisdiction, barred by law. But can you allow me to cite one judgment of Supreme Court? What the court should do, and the judgment of our division bench. Division bench judgment, 97 CWN, Calcutta weekly notes, sorry, 894. Similar to what our division bench pass an order, and thus you find this view is supported by Supreme Court, of course, without noting Calcutta High Court judgment. But same view may be explained by Supreme Court later on in the two judgments. Calcutta view without noting Calcutta view. Can you come to paragraph 7? After hearing, board dispensing in legislation referred to above, proposition law has been established. It appears from what has been stated above that we have been invited to decide in this revisional application 115, the point about maintainability of the suit. No doubt, this point does not appear to have been urged or canvassed before the trial court. But indubitably, the same is a pure question of law, our pure question of law. And the decision thereon goes to the jurisdiction of the trial court as far as prayer for interim order is concerned. Mr. Bhaskar Bhattacharjee, as a lordship there was, argument that proceeding not being maintainable is founded in the provisions of Section 69, 1 and 3 of the Indian Partnership Act. Though Mr. Kamalesh Bhattacharjee has endeavored to resist a decision on such a point at an interlocutory stage, amongst others by urging that a proceeding under Section 20 of Arbitration Act not being a suit is not covered by subsection 1 of Section 69 of Partnership Act. Factually, there is no dispute that the partnership firm in question is not registered one. Same is here, my lord. Upon consideration of the respective submissions on merit, we do not find any necessity for an investigation into the nature of the proceeding under Section 20 must be Section 20 Arbitration Act, as subsection 3 of Section 69 of the Indian Partnership Act clearly attracts the bar created by Section 69 to some proceedings other than a suit. This legal position has already been approved by the Supreme Court in the case of Jagadish, etc., AIR 1964 Supreme Court 1882, the relevant extract of which is reproduced as follows. The words other proceedings which follow must therefore receive their full meaning untrammeled by the words a claim or setup. The latter words neither intend nor can be construed to cut down the generality of the words other proceedings. Such legal position would become relevant if the next question which arises in consequence of Mr. Kamala Bhattacharya's argument deserves an affirmative answer. The question is, whether it is necessary for the court to record a prima facie finding about the maintainability of the suit while considering a prayer for grant of interim order. In the case of Reserve Bank of India, in Calcutta High Court judgment, 73 CWN 388, Justice Subhashari Mukherjee, as then was, observed, in order to consider whether prima facie case has been made out for or not, it becomes necessary to decide whether action as framed is maintainable in law. And if it is then whether the evidence and affidavits are sufficient to sustain prima facie allegation made. For the purpose of deciding the above question, it would be necessary to examine the frame of suit. Now, this is now Supreme Court has said so. I will cite Supreme Court judgment. In the law relating to injunction, etc., then judgments are sorted. Then, by accepting the correctness of the above principles, we have no hesitation in holding that while deciding the existence of prima facie case, a court must consider maintainability of a suit or action proceedings for the purpose of a prima facie satisfaction. Total exclusion of such a question from the zones of consideration of the court may result in granting relief in a proceedings which is statutorily not maintainable. This is the question, not shut down and case removed. To ask the court to shut its eyes would be a travesty of justice. In the connection, we'd like to add that depending on the stages at which court is invited to deal with the pressure. Now, this is the view of Calcutta High Court division bench and a single bench. Now, see, the Supreme Court has said the same thing. That they are persons who are applied. They can argue, yes, it is maintainable. And the Eastern firm can maintain. They can argue that. But that, Lordship, decide that point yourself.
Substitution is allowed. How can you argue the point of maintainability?
No, then not.
This judgment is relating to prima facie.
Well,
40 issues.
That is, in the respect of any proceeding, as Supreme Court judgment, I have got to have to said the same thing. 1965 Supreme Court, year 1960 Supreme Court. Now they can argue. Now, they argue proceedings are not maintainable. Or they will argue, yes, it is maintainable, despite the firm not being registered.
That's what the tribunal has said, page 110. Page 110,
Yes.
first order, it has said that I'm keeping the maintenance.
Yeah, the only thing that the cart,
Whether an unregistered firm can come up.
the only thing is not the cart has been put before the horse. It should have been the other way around. It was first decided that whether it is maintainable, and then you will be substitute. I entertain the application of substitution. The parties who have application for substitution made, they will be heard on the question of maintainability. They will be heard on the question of maintainability. And thereafter, application substitution will be decided on merits. This is the question.
That is why you ought to have preferred then at the time when the original order was passed. That how could you say that you could accept this application?
No.
This order which was passed way back on 31st of July 2014.
This order.
1st of July 2014, it was said I am maintainability point I am keeping open since Messrs. Khanna is an unregistered firm.
You
did not challenge that order. You did not challenge this July 2000.
That member can open, so when the appeal will be heard, point will be taken. Exactly. But before appeal could be heard on merits, a preliminary, interlocutory application was made.
That we will clarify, Mr. Mitro. We will say that substitution will not stop you from arguing the point of maintenance.
No, substitution cannot. There's no question of that. No, substitution cannot. We are raising only one point, Your Lordship, that whether substitution application could be entertained by the tribunal at all. This is the question I'm raising, not any other question.
Circumstances, the tribunal was required to be proceeded against a dead person.
No. That's the firm is there. Firm is there. Unregistered firm. Therefore,
the firm is being represented by one of the persons.
Then it cannot be a partnership firm.
To be one of the partners.
Yes.
Yes, guys. So unregistered.
No.
The partner.
That's one mistake I made, Lord. The firm consists of two partners when this order is passed.
Right.
One has partnership firm, when they file the name of partnership firm, it is compendious. There's two judgments I will cite to you, Lord. If one of the two partners dies, there is an automatic dissolution of the firm. Dissolution or no dissolution, whether the firm could initiate the appeal at all. That's the question. And 1965 Supreme Court, can you see me, Lord, the judgment? I'll cite, yes. What our High Court division bench says, single bench said.
Mr. Vasu, you come with a short affidavit, we will finish. 3rd March is the date fixed. You file it within 2 weeks. We are fixing the matter. Let it be through.
Very good.
Present application has been, present writ petition has been.
That will cut the matter short, beloved. We are being harassed with harassing proceedings which are especially not maintainable.
Challenging an order taken.
My lord, I did prepare on behalf of the applicant. Lord, on the last occasion, my lord was pleased to Lord inquire.
Yes.
My lord, in this case, my lord,
Opposing you,
my lord, Miss Anita Kundu, the others did not appear in spite of service. Miss Anita Kundu was there. As per my lord's direction, my lord, I have again served on her, stating that this will appear yesterday, as your lordship directed. My lord, that service was done, my lord. And Yesterday.
They are the selected parties, no?
No, my lord, they were all rejected. The question is, out of these 13, my lord, 2 was rejected on the ground of impersonations. And because of that, my lord, the learned trial court, my lord, directed that those 2 who have crossed that limit of and have passed the examination, have crossed the limit of the marks limit, that those persons must be given service, my lord, subject to the availability. These 2 has been, my lord, the allegation is impersonation against them.
Who are you? You are the authority.
My lord, we are the railways, the RPF authorities.
Achha, so which page is the order? Let us go through the order.
My lord, if your lordship kindly takes up, my lord, the memorandum of appeal, my lord, the order is annexed there, right?
You have annexed in the stay also.
Yes, my lord, I have annexed in the stay also, my lord. The stay, my lord, the order impugned is, my lord.
Here for?
I'm hearing on behalf of 1, 2, 3, 4, 5, and 9. Now, my lord.
1, 2, 3, 4, 5, 9.
4, 5, 9. Now, my lord, before my learned senior friend here concludes, my lord, I have got only one submission to make. Now, my lord, please.
He has not started.
Not started.
He has not confidence straight. He has not come. So what you are saying?
Yes, I was saying, my lord, that although a batch of writ petitioners were there, now, my lord, the matter was ultimately bifurcated between 2 sets of the writ petitioners. One set was there who were thrown out directly on the basis of certain merit. Now, my lord, the learned single judge, while deciding, did not interfere with that part. That those groups which
who have crossed the limit, who has passed got the marks.
Lesser marks than the last selected cutoff marks.
I see.
So I represent those set of writ petitioners
who scored below the
cutoff marks.
So you were thrown out.
We were thrown out. Now, my lord, this Union of India has come up assailing only a part of the order by which only 2 writ petitioners were given the benefit.
Who are they?
But they are respondents number here.
There is a section 5.
My lord, there is a section.
How many days delay?
My lord, the delay is, my lord, delay is, my lord.
Just show us who are the you are representing whom?
1, 2, 3.
1, 2, 3, 4, 5, and 9.
4, 5, and 9. And my lord, the order which has been assailed has given the benefit to number 10
and 13.
And 13.
What in their favor? What order has been passed?
Well, there was the allegation that they had impersonated by forging the LTI marks.
Then,
but ultimately, the learned court had held that no, you have to allow them, because now the Union of India being aggrieved by that part, because they would be getting the appointment in terms of the orders.
So you have nothing to say.
Yes, but my lord, my submission is this, my lord, even we are also aggrieved because straight away we are out.
So you should have preferred
an appeal. Yes.
That is what, my lord, I am saying that since I have been arrayed as a party here, but my prayer is this, my lord, kindly allows us
appellant for appellant legal.
file a
Appellant
separate
for
AVT application. That would be my prayer.
Separate?
Separate an application.
Why you are making this prayer? We have not stopped. You file the appeal, go ahead.
Now, my lord, if I am not being expunged here, if I come up later on, my lord, then it will
doesn't matter. How does that affect?
No. The lordship kindly adds only one line that if we are advised, we may come up.
My lord, how can I throw them out? They are parties in the trial court. If I throw them out, that would be misjoinder of the parties in appeal.
If you remain in the party who, in that circumstances, you will be prevented from filing an appeal.
No, my lord. If I come up later on, then this would operate as res judicata, my lord.
Why? Because
I'm made a party.
You are there in the writ petition. Their appeal will be defective if you are not added.
Yes, my lord. How can we?
Lordship kindly clarifies that only one line order would be, my lord, sufficient for us, my lord.
No, you file the appeal, we will direct it to be listed along with this matter.
No, that can be done, my lord. That can be done.
No one prevented them, my lord. They choose not to do anything.
File.
Milord,
Any contempt application filed?
content fight করেছে? Milord, most probably not. Most probably not. Milord, no, as my instruction goes, no contempt has been. Contempt has been. No contempt has been filed.
Section 5 is allowed.
Affidavit of,
Yes, Milord.
no, no. Affidavit of service.
This Milord has been filed, Milord, where Milord intended me to reflect whether that has been served on the person concerned, that is Binod Kumar and Krishna Murari Kumar, whether they have been served on.
Section 5.
In Milord, the affidavit of service, Milord wanted me to clarify whether Milord, that Binod Kumar and that Krishna Murari Kumar, Milord, who has been given the opportunity of having the service, whether they have been served or not. Milord, if your lordship kindly takes up page 10 of the affidavit of service, page 9 of the affidavit of service.
Tell the what affidavit of service.
Milord, they have been served. They have been served, they have received it. It reflects from here that both of them has been served and they have received it. And Milord, as per direction,
Okay, despite service,
Affidavit of service.
Ten. 11. 10 has appeared, Milord. 10 has appeared through Miss Anita Kundu. 10 has appeared. Yes, Milord. On the first date, Miss Anita Kundu represented the 10.
This one number 10 and 13 and file.
To 10 and 13 and to file affidavit of service.
Milord, in the meantime, if your lordship kindly allows me to file this supplementary affidavit, because some pages in the stay application was missing, which are relevant. Milord could not find out on the last section. We have prepared the supplementary affidavit, sent to them as well as to the.
And the supplementary affidavit as filed on behalf of the appellants be kept up.
Milord, supplementary. আমি দিয়ে দেবো
Give a copy to
আপনি একটু লিখে দিন
and you intimate that order along with the supplementary.
Milord, I have served them. Milord, I have already served them with to Miss Anita Kundu also, the supplementary affidavit.
10 and 13.
I'll serve him. I'll serve my learned friend.
So, there is a requirement to file any Bhokaratnama containing seal and stamp of the authority. The stamp requester has pointed out so. on your behalf.
My lord, my learned friend is the advocate on record. File করুন।
ওকালতনামা
File
which you have
My lord, we will file it. If it is not filed, we will file it. তুমি ওকালতনামা ফাইল করনি। কি আশ্চর্য।
My lord, liberty to file separate. Liberty to file separate. That is not required. It is not.
তোমাকে বলতে হবে।
We have kept
লিভ দিতে
it
হবে
on that
তোকে।
30.
ওকালতনামা ফাইল করার
In
জন্য।
the
কি
meantime,
আশ্চর্য।
file the appeal and mention before us, we will incorporate, it will be listed on 13th.
Yes, full my lord.
Remind us with a copy to Mr.
Yes, my lord.
Grateful, my lord.
আপনি নাম আর নাম্বার মাত্র
I'm appealing on behalf
নাম
of
দিয়ে
the On last occasion, it was heard by your lordship, this is the matter relating to compulsory appointment. The father of the petitioner was an employee of SBI, Maruti branch. He died while he is in service. The appellant filed an application within time according to old scheme introduced by the state bank authorities.
So, Mr. Saha, do you want your case to be considered for ex gratia?
Yes.
Huh? Yes, Mr. Sinha, what instruction did
My
you?
lord, similar situation occurred before the another court bench presided over by Honorable Justice Subhuta Dharma. Similar situation, document was not available. There also, it was considered, it was directed bank, considered, my what by lordship suggested, considered whether he's engaged. In the judgment is here. That I am placing the judgment. There
No,
he
what
said,
happened? Yes,
yes,
tell
my
us.
lord. So only thing is one directions, bank, the other day my lord observed, which is, how much money you will pay. That to ask, and no specific order was given, that then level. Now, if I calculate and say the amount, that for a lot of cases will open, my lord. Similar situation, and 100 cases will open. Because last year, 10 cases were decided in the extent of compulsion upon State Bank of India. And 9 cases decided in favor of the bank. So therefore, I am not contesting it. What I'm asking, my lord, give me directions under compulsion of a scheme, execution scheme, how much scheme, how much money bank will pay. What will be direction we? Then we can put up the computer up to corporate office that this is the situations, and let us we'll come back. Then my lord will accept it, may not accept it. Only one direction, my lord. Because if we show more to place it before the court, then all of the cases, my lord, they will take the plea. The bank agreed to pay under the scheme.
Show us the order of
that I'm showing. একটা কপি দেবেন একটা কপি না লাগবে দেবী মন্দির একটু আচ্ছা নেন আর একটা একটা দিন না নিন পরে পরে নিয়ে নেবো
In this case, both compassionate appointment and ex gratia benefit was denied.
Was
denied. That was challenged.
originally. Then the compassionate appointment scheme, we came there because there some documents are missing. It was not up to place before the CGM. Then they said your CGM to reconsider it.
No, you took the point that question of review at this stage does not occur.
Because my lord, all the
But ultimately court directed considered in terms of, but today, if upon considering tomorrow you say you will not get pension ex gratia also.
Let me come back with the amount, my lord. Let me come back with the amount. What amount will give?
Yes,
Max amount is in the scheme we have enclosed. Max amount is 6 lakhs is there. Let us see how much money will pay.
That is exactly what we wanted.
That is why, my lord, only one thing, my lord, if I so would come and say that this much amount is pay, X amount will pay. My lord, then they said bank is authorized to calculate it, so much submitted with the court. So in our case, court calculated.
What do you want?
Only 7 days time, my lord, to calculate how much money will pay will pay.
That is what we wanted. Come and tell us that this is the amount, and
my lord, we decide whether this amount payable or not, or then.
Because otherwise it will be suspended animation. Again,
No,
we will direct
20 years has already, only thing is, my lord, humbly submitting, my lord. Compassion appointment either in ex gratia scheme or a compassion appointment based upon penury, instant penury of the family. Now 20 years have passed. The judgment they have cited, that is judgment rules. But in our case, it is a scheme. The Supreme Court emphatically said.
Maulananda Sethi.
That is a rule.
The appellant has become a victim, paragraph 7, victim of the delay or an inaction.
Amounts which you get under the new list.
Now
In
the
in the event of
person
in the event completion of the following cannot be found. Such cases employees may be similar to the in case conflict. Payment exceptions. Simply legislation scheme how much money is
not that.
in course of hearing. This court wanted So will we ask any of your officer to file in the form of a report? Will that help you? Or you will be able to avail written instruction?
On the basis of the order, my lord, I will ask them to
All right,
calculate it
all
and
right.
interview me. I will place the
compute?
I will place the instructions. This
To
now.
compute and
My lord, may I have my lord's indulgence, my lord? My lord, here, my lord, Mr. Shivsharna Bandyopadhyay is leading me, my lord. And my lord, this is a matter which has some financial importance, my lord. If my lord,
Yeah.
no, my lord,
about you.
this is more than 200 crores, my lord. Will
Sure.
try to understand, my lord. Only a short passover, my lord, of 15 minutes, my lord. Mr. Bandyopadhyay.
Have you completed service? Have you
Evidence of
served
service?
upon the respondents?
My lord, they appeared in the contempt and they said that the appeals are with them.
When is the contempt?
My lord, the contempt is on Friday. My lord, 15-20 minutes, my lord, at 1 p.m., my lord, we will come back. My lord.
Appeared for them.
My lord,
Nobody appeared.
my lord, Shonjit Kumar Ghosh, my lord, and I think, my lord, the advocate on record is Orijit Mohinder.
Where is your affidavit of service?
My lord, affidavit of service, my lord, will kindly passes it over, my lord. I shall bring that affidavit of service also, my lord, somehow it isn't.
Section 5 have you served? There is a
My lord, section 5, my lord, the delay of 300 days, my lord. My lord, we have served, my lord. They appeared for the contempt, my lord. It was recorded that the appeals have been filed. They were there, my lord. But a short passover, my lord. That is all I am seeking.
We cannot do it in their absence, no?
My lord, we shall also intimate once again that the matter was taken up and it will be.
You intimate your other side,
My
we
lord.
take it up on Friday. Yes, not today. Next.
My lord, at 1 p.m. if possible today, my lord. At today 1 p.m., my lord. If
Passover.
passover, my lord.
You cannot stay the content proceeding in a defective appeal, no?
My lord.
Section 5 is not allowed. That is why we were keeping it on Friday. Anyway, if you want it. Friday is the contempt application before the court. It has been
With the personal appearance, my lord.
personal appearance. Rule has been issued.
No.
Earlier.
Not
Friday. Yes, not today.
my lord. Oblige. My lord, fairly at the top, my lord. If fairly at the top, my lord, if it is subject to my lord. My lord. Oblige, my lord.
And complete service and everything.
My lord,
will be in time.
my lord, my lord, my lord, my lord.
Yes, next.
Oblige, my lord.
Lord, I am for the appellant. Lord, I have served the copy.
Yes, we have received. My lord,
Lord,
the copies
that
of the section 5 application
Lord,
as well as the stay application.
Lord,
Delay
the
of
delay-
how many days?
23
24
years.
20,
Eh?
almost
23 years,
24 years.
335 days. And not only that.
Let me speak.
না জজ সাহেব জিজ্ঞেস করছেন তো আমার
আচ্ছা,
আপনাকে না আমাকে জিজ্ঞেস করছেন
Yes,
Lord,
sir. Tell us.
yes, my lord. The order impugned was passed in 2000, December 2000.
December 2000.
Yes, my lord. Thereafter, on the wrong advice, a writ application was filed in 2009. And that writ application was dismissed for default in 2023.
8,000 days old.
How could you convince your client to come and file the appeal?
My lord, since the order impugned is very much interesting, my lord, kindly have a look at the order. It is
You have
violation of BSF Act as well as BSF rules.
So now you came to learn after 25 years that I must go and challenge this.
My lord, yes, it is a mercy petition. My lord, kindly have a
What mercy, sir? What is the age of your client now?
58.
Termination is 2000. What you are doing, sir?
My lord, it's a kindly have a look at the impugned order. It's a violation of all kinds of.
And they have filed also a fresh writ petition. They have also filed a fresh writ petition without filing the appeal. That is, your lordship will got in, my lord, paragraph 32
That I
order
have
from the
submitted.
stay application.
That I have submitted.
That was dismissed for default. No restoration.
Got the section 5, Mr. Mitro?
Yes.
File a detailed.
My lord, section 5 challenging the order of Justice Ghosh as his lordship then was. But my lord, without assailing the appeal, again they filed a
say that in your affidavit. Na?
Yes,
We will dismiss his application.
yes.
We are set.
Jan 1 of 2024. I said, this
My lord, I appear for the respondent, my lord. By the previous order, your lordship had directed us to disclose certain documents which we intend to rely upon by way of a supplementary affidavit or an affidavit, my lord, on by order dated, my lord, 20th of December. Unfortunately, my lord, the respondent, my lord, he is indisposed. My lord, he could not come to court to affirm it. So, my lord, if your lordship should kindly permit me a week's time, or my lord, if I may file all those documents by way of a convenience compilation, because all of those are part of the writ petition. This is just a affidavit in reply and a supplementary affidavit, which we had relied upon in the writ
No,
petition.
we said, Mr. Mojumdar said that we want to file an affidavit only for the those documents and pleadings used by the parties before the signature.
My lord,
Whatever missing documents are there, you file the supplementary affidavit. That
But
is
that
what was stated.
supplementary affidavit, my lord, would have to be affirmed, my lord. He is not in a position to come to court, my lord. He was not. But hopefully, my lord, if your lordship kindly gives me a week's time or a fortnight, preferably, my lord.
Well, if time may be granted, my lord, order of the trial court will become operative, my lord. My lord, that's
My lord,
why,
we
my
shall
lord,
not proceed
my
with
lord, my
File.
No, my lord.
file, my lord, but it will become operative, my lord, within a short period, my lord. So, my lord, give me some
Not fine,
protection.
my lord. We shall not, my
No,
lord.
no,
I'm
that-
undertaking before your lordship, my lord. We
that
shall
may
not proceed.
undertake recorded, my lord.
We shall not proceed, my lord.
Application ही तो file करें.
No, my lord.
We have not filed an application, my lord. Stay application is pending, my lord. I'm an officer of your lordship's court, my lord. I am undertaking. We will not.
No, no,
We
that's
will not
true,
file.
my, that's true, my
The
lord.
stay
because
application is also pending, my lord. This is in the stay application, my
No,
lord. Your lordships had
that does not, my
desired that your lordships would dispose of the entire matter at the stage of the stay application.
8/8/2014, 24.
lord.
Direction was given to pay retirement with pension, etc. within
6 months.
6 months. So
6
6 months will.
That would also take us to the first week of February, my lord. Before that, I shall file it, my lord.
February.
Uh,
2 weeks.
then my lord, after 12 of February, date may be fixed, my lord. I'm difficult.
But Mr. Chakraborty, learned advocate, appeared in court. Please the matter.
21 my lord, I'm appearing for the appellant.
On the last occasion, my lord, it was heard by your lordship extensively, and my learned friend was asked to bring, my lord, instruction as to what is the necessity in keeping me suspended even after 90 days when the charge sheet was filed on 91st day. By virtue of the impugned order, my lord, my writ petition has been dismissed. Challenging that order, my lord, I am before your lordship. 4th of September, my lord, I was suspended. 2nd December was the 90th day of my suspension, and on 3rd of December at 1:20 AM, my lord, the copy of the charge sheet has been posted from a post office, and it reached me on 3rd of February, December, my lord, in the afternoon. So, my lord, as per CCS rules, my lord, I am suspended under Rule 10 of Rule 10(1) of 1A of CCS rules. Now, my lord, as per the rules, the suspension should remain for 90 days, and if the authority wants to keep me under suspension, my lord, as per Rule 6, Sub-Rule 6, Rule 10, Sub-Rule 6, and Sub-Rule 7, my lord, if you lord, এটাও দিয়ে দিন, দুটো আছে। If your lordships kindly sees, my lord, Rule 10, Sub-Rule 6 and 7 simultaneously, my lord, it says that,
Just a moment.
my lord,
CCA rule, CCA rule. Work of CCA rule.
Huge.
first, my lord, kindly see the impugned order. That is with the memorandum of the appeal,
Yes.
my lord.
What was the charge? No proceeding. What is the charge?
Charge was that, my lord, I have not traveled. I am a field officer, and I am supposed to travel different states to visit the libraries.
Yeah, just a moment. You are placed where now?
Guwahati. On the date of my suspension, I was posted at Guwahati.
Then why you have filed the writ petition here?
I do not find.
No, I'm, my lord, my office has 5 zones. Right now, I am in northeastern zone. Head office is here at Salt Lake.
I see.
And
So who issued the order of suspension?
the Director General, Raja Rammohan Roy Library Foundation, the respondent number 2. He is my appointing authority and my lord, suspending authority. Now, I got my
Annex the writ petition.
I tender my apology, my lord. I have not, but my lord, I'm handing over my writ petition to your lordships. Kindly excuse me, my lord. Kindly excuse me. That's the only mistake I did, my lord. And my lord, kindly takes the supplementary affidavit. This is also recorded in the impugned order also, my lord. Didi. This is the supplementary affidavit and the writ petition I have handed over to your lordship also.
The suspension of আর আমাকে ট্রান্সফার করে দেওয়া হোক কলকাতা
পরে আসবে সাসপেনশন
হ্যাঁ পরবর্তীকালে চাষে কিছু চ্যালেঞ্জিং
কিন্তু ও চার্জশিটের সম্পর্কে মানে
পুরো বলেছে
Have you brought that judgment of which was relied upon by the court?
No, that judgment I have not brought, but my lord, another judgment that
What
that is there, my lord, that is settled. That my lord, suspension regarding suspension, that is settled, my lord. The 2013-16 SCC, my lord, 147. The court is cautious and slow in interfering with the disciplinary proceeding and normally permit the same to be brought in logical conclusion. That is there. Now, my lord,
16 SCC page
2013-16 SCC page 147. That is referred by the learned single bench, my lord. And the other one is 2006 volume 8 SCC 2000, 200. Now, my lord, that is there. That is settled. But, my lord, if the charge sheet
was the order of suspension.
suspension order, my lord, at page 59B, 59B.
So where is the charge sheet?
Charge sheet is at page, my lord, 72. And kindly see, my lord, the charge sheet differs.
Did not challenge the charge sheet.
No, charge sheet, my lord, I have not challenged, but the charge sheet, my lord, has been issued during pendency of the writ petition, my lord, before the
Writ court has considered that.
writ court has said that after filing the writ petition,
But you have not taken the
no, I have replied to that.
90 days point.
90 days point I have taken in my reply.
Reply to the writ petition.
No, reply to the charge sheet. They have asked me to
Tell the court that point.
I told the court that since the supplementary affidavit has also been filed and the matter motion hearing is awaiting, my lord, I was, my lord, I have prayed for before the court that kindly give me an opportunity to file either an affidavit or an application to bring this charge sheet and the reply to the charge sheet on record. But, my lord, the writ petition has been dismissed. The court has recorded, my lord, after filing the writ petition and after affirming the supplementary affidavit, the charge sheet has been filed.
Charge against you is that you have misappropriated an amount for towards traveling allowance.
Yes, and that amount, my lord, it is not recorded that that amount I have refunded to them. Kindly see page 59.
Then you admit the charge.
No, I don't admit the charge. I tell your lordship, they raise point, allegation against me that I have not traveled to Nagaland, Mizoram and Sikkim. Now, so far as Nagaland tour is concerned, my lord, I have submitted my report. I have in my office, my lord, there is a circular that I'm a field officer. Every field officer it is mandatory for every field officer to post the reports, photographs, and other things on Twitter. That is mandatory. There is a circular. On the basis of that circular, my lord, I have posted the reports, the photographs, everything in Twitter. And the particular respondent number 2, the Director General, he liked those posts and he, my lord, reposted those posts in Twitter. I have given those details in my regarding Nagaland. So far as Mizoram and Sikkim is concerned,
Behind, we can hear you. Please keep the mic aside.
so far as, my lord, Mizoram and Sikkim is concerned, my lord, I have withdrawn those 2 reports. I have given them a letter that there are some technical and typographical mistakes in my reports. I am withdrawing the reports and I am ready to refund the money. Kindly tell us the modality of refunding the money. They have not done anything.
You have admitted the charge.
No, I have not admitted the charge, my lord. It has happened, my lord, in August. It has happened. They
paid the amount in August.
I paid the amount on August.
Yes.
And I got suspended, my lord, till date, my lord, the date on which I have refunded the money, my lord. It was not, my lord, the suspension was not there. Nothing was there. I was working as if, my lord, I was working there for from January 2023. Now, my lord, after 2 weeks from the refund of the money, my lord, I got the suspension order. Now, the charge sheet differs from the suspension order. If your lordship kindly sees the charge sheet in Annex 2, my lord, it has been stated that I
was not a subject matter of challenge.
Charge sheet is the continuation, my lord. Charge sheet is the initiation
to the query.
Charge sheet was not subject matter of the challenge in the expedition.
No.
So court took cognizance of the subsequent act, but court did not allow the said charge sheet to be brought on the court. And the learned court did not consider the justification of the charge sheet also. So as appellate forum, we cannot enter into that arena. But now the only challenge was the suspension order, and you sought for a direction upon the authority to transfer you to Kolkata.
Then, my lord, let me confine me in the suspension only. Suspension, my lord.
Without issuing any so-called notice, suspension order was issued.
That was also I am not taking.
Only this question.
Only this question, my lord, no show cause was there. No letter was there, nothing. I am not taking that point also. No, I am taking only the point of suspension. I should be in suspension for 90 days. Within 90 days, as per CCS, my lord, a charge sheet has to be filed. If
where is which provision you are
Rule 10, sub-rule 6 and 7, if your lordship kindly sees.
So no, where is the provision towards show cause prior to suspension?
No, that is not there. That's why, my lord, I have not taken that. I have not taken. I have not argued that also. I have not argued that also. Only the suspension.
So there was no review order given?
No, nothing. On 91st day?
91st day, the charge sheet
was issued. Was rather, my lord, posted from a post office at 1:20 a.m. From a post office that remains open for 24 hours. So, in effect, my lord, as per
charge sheet was issued on.
Kindly see the track report that I have annexed, my lord.
Second, where does it say 90 days? It will stand revoked if it has not been reviewed. If your suspension is not reviewed within 90 days, it will stand revoked. That is the provision.
That is the provision, and that is the judgment also. I shall rely on that.
All right. And show us that where is the charge sheet? Charge sheet was dated
72, page 72. It was dated 2nd of
December.
December. This is the 90th day. This is the 90th day. On this date also, my lord, it was not served upon me.
It was served upon you when?
On 3rd of December at 1:20 AM. Kindly see the track report as at page 120. Kindly see the track report. They have given my phone number, my lord. Page 120. This is the track report. When they have posted it.
Yes.
Kindly see 3rd of December at the last entry, my lord. 3rd of December, 112. I stand correct at 1:12 AM. This is the 91st day.
112.
0112. My lord,
That is on
3rd.
15th August.
No, page 120.
Page 120. First is 3rd December 2024.
All the dates are, my lord, 3rd
3rd
December
December
2020.
2024. It was posted at the time. It is 3rd. What is this? Your page 121.
20. 120.
120 date is 3rd December.
Yes. That is the 91st day.
Acha, 3rd December.
3rd December.
It was posted in Rabindranagar on 3
No,
PM.
it was Rabindranagar is my post office. Kindly see the bottom last entry.
Oh.
BNCC block BOBPC. This is the post
It was
office.
posted at night.
At night, 1:12 AM. Rabindranagar received it at 8:29 AM. And I have received it at 3:08 AM, PM.
Yes, Mr. Nondi. Show it that you have revoked the order.
You have extended
Review.
before expiry of 90 days.
I am submitting. I am placing the document. Your lordship kindly take to instruction whether why this suspension is continuing after the lapse of 90 days. Your lordship kindly says with and reply to the charge you will find.
The charge we are not considering.
Only, I know, they have not charged, but only reflection, my lord, this statement made by is not correct one. Your lordship kindly says this order instruction I got.
What?
Yes. Last part, last one.
Give a copy to me.
Other part is there. Your lordship kindly says.
What is this? This is Article 2.
Hmm?
Charge Article 2.
No. This is the charge has been issued on last left. Further, it is mentioned the charge sheet was served on C. Das email on 22nd December within 90 days. As you got last time. But when the departmental is proceeding is pending, my lord, the question of suspension is not is required to be. The series of judgment is there, my lord. Suspension, my lord, is there for pending departmental proceeding. It is required to smooth conduct of the departmental proceeding. Suspension is required. Your lordship is what is the charge against him? 1, 2, 3, 4. I have handed over the copy. My lord, your lordship is grave charge. Your lordship is. What is the allegation? I am not that point. I only question whether the charge has been filed, submitted within the time or not. 90 days. Furthermore,
You come to 10 sub-rule 7.
Sub-rule.
If you not with the book, I am reading for you.
I have got the book, CCA rules. I do not find 7. I have to 6.
An order of suspension may or need to have been made under sub-rule 1 and 2 of this shall not be valid.
এই বইটা আমাদের নেই, এটা আমার বইয়ে নেই, এটা আমার বইয়ে নেই।
Got it? 7? Sub-rule 7,
Yes,
an order of suspension made
or deemed to have been
have
made.
been made under sub-rule 1 and 2 of this rule shall not be valid after a period of 90 days
Hmm.
unless it is extended after review for a further period before expiry of 90 days. So you are still keeping him under suspension. So you show that you before 90 days decided to extend.
That is the clause is there specifically. But we have served, my lord, but
What will you
only, yes, I got understand. my lord. Within 90,
Does not say about service of charge sheet. It says that it has to be reviewed within 90
within
days.
90 days.
If you have not reviewed, then it will stand set aside.
Revoked.
So you will join and work and you
will-
go on with the disciplinary proceedings.
He will go and join his place of work.
Only one day, my lord. Only one day, time, I have to go to this book. I have got no book, so I have to take some instruction from the book, my lord. I have to reveal whether
What is the stage of the disciplinary proceeding?
that is going on.
Lying there.
Is there?
They have
your
not
lordship
replied
knows,
within
yeah, when the
1.5 months
yes,
has been passed
the
from my
serious
reply,
allegation
milord.
is
They have
there,
not replied.
departmental proceeding is
Mr.
I know, I know.
Experienced
Your
person, we
question, my lord, no question of the
you have
challenge.
obtained orders in your favor on this rule. So you please tell us that you know very well, unless the review order is served upon him.
It is stand revoked. Deemed to be.
Then-
Milord, I have to take, milord, only, milord, one day time.
That
milord.
is why we gave you time, na?
Only, milord, this part, milord, I have to take only one day. milord.
If it is not, it will stand revoked automatically.
Yes. And
Unless revoked. We shall not-
I know that I am not questioning.
One
They have
thing-
challenged the order of suspension.
One
That
thing,
is not-
milord,
no question of charge
9th
sheet.
of December, I have given my reply to the charge sheet. Till date, they are keeping mum. They have
Again,
not
you are-
given anything.
Charge it.
Not today. It's not.
Milord,
Friday.
no, milord, kindly keep it after 30th, milord. From Friday, milord, I shall be out of station. I shall come back on 30th.
ওই বইটা হয়ে গেল নেই
Only on the ground.
You have filed a stay application. Mr. You have filed a stay application.
I have filed an injunction, milord. Basically, it's a stay.
Then you use a short affidavit to that within 1 week. Disclosing your reasons that why you
Yes.
have whether you issued any revoking or review order or not. Explain that.
Your lordship, where is the authority concerned who is supposed to affirm the out of station that is gone to without one.
No,
2
the
years, milord?
others are there, milord. 3 and 4.
I have no objection, milord.
3 and 4 are there, milord. They are, milord, the deputy directors. In absence, milord, they can do it.
You file an affidavit, Mr. Mondi. Within 1 week, you file it. He will give a reply within a week.
1 week.
Huh?
What week, my lord?
Milord, I am
Unnecessary
without
is
money for
proceeding.
quite a long time, milord,
If you
because
wait for
I am not, milord, taking, milord, I am not taking subsistence allowance. That is the difficulty.
Alright, today is Wednesday. Come on next Wednesday then.
Next Wednesday.
Come on next Wednesday.
And you file supplementary
Milord,
affidavit.
kindly keep it on Thursday. Wednesday I am coming. 30th I am coming.
What
Wednesday.
is the supplementary affidavit?
Supplement by the supplementary affidavit, milord? No, it's not. I have given off.
But you file supplementary affidavit annexing the writ petition. and-
Definitely, milord.
Huh?
Definitely. If he files the reply opposition, milord, I shall definitely file the reply annexing these documents. One thing, milord, I am praying. I am not taking any money. By this time, milord, since I have
Want to keep it on Friday, then you are not there on Friday.
that is the difficulty, milord. I am not.
আপনার সুবিধা মতো নিন না আমার অসুবিধা নেই আপনি বলুন
They will be happy.
no question of happiness
Friday morning,
no
milord.
question of happiness
Friday morning, Friday, kindly keep it at the top, milord. in the evening I have to leave. Milord, I'll kindly keep it at the top. I shall come back. I shall come back on Friday. I shall come back on Friday. Kindly keep it at the top.
Do you want to use it, to put that on record, or you do not want? Affidavit is not required. Then we keep it on next Wednesday. In the meantime, what instruction you have? Next what?
Thursday, 31st.
Instruction by way of affidavit or a verbal.
Then affidavit you file within a week.
তিরিশের পরে ফাইল করুন, হ্যাঁ 30-এর পরে আমাকে সার্ভ করুন, 30 অব্দি আমার কথা। I will take 3 days to file the reply if they files the opposition.
Where is the suspension order? Order of suspension?
Order of suspension, my lord, page 59B, 59B.
59B.
B.
বইটা জোয়ার বই আমার তো বইতে নেই আমার ভাই।
এখানে লাস্ট ইমেইলে date of submission.
সেটা চার্জশিট করতে হবে, কিন্তু রিভিউ করতে হবে সাসপেনশন অর্ডারটা। না
একটু বইটা দাও।
Milord.
Rule 10(7).
75.
Rule 10(7) open for us. Rule 10(7).
So the present petition has been preferred. The present appeal has been you make a Xerox of this rule and give us a copy.
I shall take a printout of the entire rule and I shall hand it over
Oh,
to
no,
you.
no, not this one. You will get it. Ready? So 1 PM till take it up. Take it up. আসেনি? না, না, ওদের ওই অর্ডারটা দেওয়া আছে। আইটেম নাম্বার না না যেটা ফরওয়ার্ডার্সে আছে 1 নম্বর। No, no, Mr. Ghosh, just give us 10 minutes. We will pass an order.
Yes.
54. Ashok, the contentious issue. The content. Is supplement.
These are the supplementary.
Yes, Mr. Ghosh.
Yes, ma'am.
Well, I was just thinking, well, this is a matter of almost a matter of first impression. The interim order application is being heard. Well, I feel, to be honest to your lordship, that the appeal is to be heard. This is the point involved in this should be finally decided. So, my lord, I would suggest this, my lord, subject to your lordship's pleasure, that kindly fix a date for hearing of the appeal as early as possible, subject to your lordship's convenience. In the meantime, we will not take any steps until the appeal is heard by your lordship. So that will satisfy my learned friend. And the papers will be filed because half the papers are not there. Half the papers today, my lord, another brief as this has been given. This should be there before your lordship. All the papers should be there. I mean, unnecessarily, I don't want to waste your lordship's time by
Mr.
having.
Mitra, will you file the paper book then? It is up. We will direct him because Mr. Ghosh, you have all the documents.
Well, if my client had been a private party, I would have relied upon him. But for since
We are also state.
I don't.
তবে আমরা যদি দেখি যে এখানে সবকিছু আছে তাহলে this can be treated as a
তোমরা
paper book.
করতে পারবে পেপার করতে হবে
Paper book টা অনেক সময় নিয়ে নেবে।
তুমি কত সময় নেবে
আমি বলছি এইটাই ইনফর্মাল পেপার বুক ট্রিট হয়ে যাবে দুটোকে।
এটা পারবে এবে পাওয়া যাবে না কিছু কি হবে
দূষিত হয়েছে
হ্যাঁ
এত জায়গায়
একটা কন্টিনিউয়াস পেজ নাম্বার না থাকলে একটা ইন্ডেক্স না থাকলে my lords will not be able to follow these things in the papers. I just wanted to cut short the matter so that my lord, your lordship's time is not wasted by hearing the interlocutory application. Let the appeal be heard. This is a matter, my lord, in which, my lord, I feel, subject to what Mr. Ghosh says, that it is a matter in which, my lord, the appeal should be heard. And instead of having a piecemeal hearing,
We can do one thing also, we can file an index.
আমরা পেপার বিল ফাইল করতে পারবো নিতে পারবেন ক্যান ইউ টেক দ্য রেসপন্সিবিলিটি ওকে জিজ্ঞেস করো আমরা করে দেবো তাহলে বোধহয় দ্যাট উইল বি ইজিয়ার নাকি তোমরা ফাইল করতে পারবে তো
আচ্ছা advocate appealing for the respective parties.
মেনশন করে দাও না আজকে আসুন
ফাইলটা দিলে প্রথম ফাইলটা
plan for the railways. Please for
Your Lordship, I am appearing on behalf of the petitioners.
For the reasons discussed above, we are not inclined to interfere with the impugned order of dismissal of the OS, and the writ petitions are accordingly dismissed. Sorry, Ms. Shah.
grateful.
Obliged, Your Lordship.
Then to my I am for the petition. Appellant.
Yes.
But this matter relates to pension of a bank employee. And I am aggrieved by the order. Impugned order, my lord. 12th November 2024. This is the order, my lord. Page, last page, my lord. 97, it starts from 97. And page 11, point number 6.
Have you served?
Yes, I have already served. my lord. This is the evidence service. Serve everybody. Inner page 4, page 100, my lord. Point number 6.
Just yes.
Lord, point number 6. When the petitioner has accepted the terminal benefits without any protest, the petitioner could not have initiated the instant writ petition praying for payment of pension benefits. So, my lord, terminal benefit and
Have you
pension,
read the earlier paragraphs?
my lord,
Have you read only paragraph 6 or the earlier paragraph?
earlier paragraph is this, my lord, several occasions this matter was filed in different court, but that was not regarding pension.
So you will not tell that. You were dismissed for service, you will not say that that was required.
Lord, situation is this.
Why do you accept such briefs, sir?
I have completed, my lord, 10 years of service.
You were dismissed from service. You don't know. Written there. That is why you have not seen the first 5 paragraphs.
Dismissal will forfeit your entitlement for pension. Entitlement to pension. Since you have dismissed, you are not entitled to get pension.
Yes, my lord.
So, whatever due, despite the same, whatever the due they have paid, and you have accepted the same without any protest. Now, why are you do this? You are doing this.
I have been dismissed from service, my lord. But actually, my lord, kindly have for a moment, kindly see, my lord, one thing. That in my affidavit in reply, page, my lord, 90, that was not submitted before the single bench because I was absent during that time. But more for a moment, kindly see, my lord. Page 90, my lord.
Have you gone through the brief properly? Because cost was about to be imposed. You read the paragraphs 1 to 5. You must have read it. After this, what more you have to say? What you are showing? Paragraph?
Paragraph, page 90, my lord. Page 90.
19.
90.
90.
My application, my lord.
Where is 90 page?
Page 90.
There is no page 90 in our brief.
That is my affidavit in reply file.
Okay, what affidavit in reply you have stated? Tell us what you have stated.
Actually, my lord, that the employee was appointed in the year 1984.
Forget about whether you dismissed from service or not. You challenge the said dismissal order by filing a writ petition. The writ petition was dismissed. Thereafter, you prepared the appeal because appeal was dismissed. So dismissal order stands.
But kindly, very well.
Now you again file a writ petition, paying a direction, ask them to pay pension.
But kindly give me one week time, my lord. 1 week.
No 1 week time.
Kindly, my lord.
We shall count the hour you are questioning. Judicial hour.
But kindly 1 week.
Tell how much cost you will pay.
But kindly provide 1 week time.
How you will pay? By check or demand? How much? Mode of payment and amount. Except this, nothing. Most probably left side here. Court act, we can judicial notice. Yes, how much you will pay and how?
But I just praying for 1 week time, Lord, kindly provide me that. Thereafter,
For collecting money.
Thereafter, my dismiss.
Cost.
Whatever it is.
Paying for time, collect the amount, the cost to be awarded after time of dismissal of this appeal.
All right, kindly.
So,
where is your affidavit of service?
Yes, I have. Oh, thank you, Chief. tender my apology, my lord.
Withdraw.
Withdraw
That
the
Withdraw this appeal. There is nothing. Don't waste the judicial hour. Let the court consider other important matters.
then I will.
On the pair of the Mr. Ahmed Ranet advocate. In this matter, I appear on behalf. Yes. Not the
yes.
case is unique in its character.
What are the applications, Mr. Singh?
Lord, I asked my learned junior, said, I do not know because we have not made any application. Maybe one for expeditious hearing, one for all made by the other side.
Who is opposing you? You are there.
I'm for the
You are for the
respondent.
assigned to us. How many benches heard it, Mr.
Lord, checkered career, it started with Justice Rutinma Bhattacharya. And Lord, it has traveled from court to court, ultimately to before your lordship. I tell your lordship the reason. When it came before the Division of Justice Tipon, after hearing for 15 minutes, the lordship said, even if you lose, you don't lose anything. I don't know. Because I have a duty to press my client's case. And I told the other side, even if you win, you don't get anything.
So it has become academic.
Yes. And therefore, he said, you try to settle it between yourselves. We tried our best. We gave an offer, but it was not acceptable to them. So we told the grand judge that this is not possible because they have not, the bench said, you give your counter proposal. Then we can, our counter proposal is whatever was in the charter of demand, which is the subject matter of reference, entire thing. So if I give entire thing, I fight it out and say, in fact, I have no establishment now, no asset now, nothing. So we'll have to spend some money to be told that nothing is recovered. That's the whole difficulty.
This Bojboj floor coverings is no longer existed.
On record, maybe, but it does not have an establishment, does not do any business, nothing of that sort.
Then what happened? After that, the proposal was given.
Proposal was not that they said everything to be given. Said everything to be given.
Then, what happened to the next bench? Why did the bench release?
Same thing. Send us to see whether it can be compromised, can be arrived at. Because this is the factual position. Again, Lord, it failed. Last time, Lord, when it came before the other division bench, the bench had no determination. That is why it was released. And that is why it has been assigned before Lordship.
Yes, Mr.
No, I tell your lordship, your lordship need not be troubled with the brief right now. I tell your lordship the facts in short, then take your lordship to the relevant pages. My lord, there was a charter of demand given by the union. The company said it's not possible for us to give this much. We can give you this much, not beyond that. Then some agitation started. And agitation in what sense? It's a chain process of production. If one unit stops functioning, then the chain production stops. So we inform the police, we inform them, don't do this. I shall take your lordship to the notices. Nothing happened. Then, my lord, we had to declare our lockout. After we declared lockout, the matter was taken up with conciliation. Nothing transpired. So, my lord, two issues were referred. One is whether the lockout is justified, and the other is whether the demands made in the charter of demand are justified. Some of the demands. And but I have not, during the last 50 years, come across any such award which says, second issue, parties should mediate and decide. You know, why it has been referred to the tribunal. The first issue is as though charter of demand is justified, therefore lockout is unjustified, therefore give relief. Without deciding the second issue, no one could have come to the first one. This is sum and substance of the case that I shall be arguing before us. Now, lordship will kindly see the first order passed by the division bench while granting stay.
That is in which volume?
There were 5 operating trade unions. Only one is orderটা বলো জ্যোতির অর্ডারটা কোথায় 509 page 509 the lordships are pleased to come. Okay. Right.
Page?
I give you lordship. It's in your lordships. But the order sheet of the court will show that. Dated 19th of November 2014 in the order sheet.
Page.
It's in your lordship's
our
order sheet.
Oh.
Right.
equivalent to
19th of November.
19th of November.
Yes.
Now they are represented. They are
Out
represented.
of 5 trade unions, one is only contesting.
Mr. Bhattacharya is for which?
That union. Five. It's not 5. Other unions have left the field.
What can they do?
No. I don't know what can they do. They can do like your union does.
So frustrated because of time.
But
They had to
actually,
declare.
I told you lordship at the outset, nothing remains. Even if Mr. Bhattacharya's client,
Take us to the order impugn, we will go.
yes, before that, only one. This order, your lordship will find they made an application under section 17B of the Industrial Disputes Act. They could say it does not arise because there was never any termination of service. If there is no termination of service, section 17B of the Industrial Disputes Act is not attractive at all. So that was rejected. Then, the court observed, we are of the view that an arguable case has been made out.
That is which order you are reading, Mr.
I am reading the order dated 13th August 2014. Page 509 of the paper.
Yeah, that is what we are thinking. We won't be able to finish it.
I know your lordship will be. Otherwise,
we have a technical side bench also.
আপনারা অন্যগুলো মার্চে রাখছেন first week of March.
Yes, what do you say?
I have only appeal if your lordship fixes it, after 13th of February or 3rd week of March. There will be a gap between 13th of February and 2nd of March. In between that or thereafter, because budget session will be over by end of March.
So on the joint prayer of the parties, the matter stands adjourned. This is the matter for further consideration under the same heading. The daily supplementary list of the report on 11th March.
11th March.
Gentlemen.
May it please your lordship. I am appearing for the appellants, your lordship. The essential grievance in the writ petition, I'll just indicate, I'll not take 2 minutes because I do understand there's a constraint of your lordships. I only want an attention. Lordship, essentially the petitioners entered into a public-private partnership with the respondent government to develop a property. There were certain disputes and failure. In that agreement, development agreement, there was an arbitration clause. An arbitration, in pendency of the arbitration, since the challenge was the subsequent another wing of the government has terminated the lease which was granted in my favor. So we initiated arbitration against the government and there's an award. It's a 3-member tribunal. It was an award passed in our favor in 2017. Before putting the award into execution, certain actions were taken by the government by putting their signage board in the subject property where I had substantially developed and I was not allowed to enter. So instead, the appellants before your lordship, instead of filing an execution, they have filed a writ petition. In the writ, I am for the appellant. So what has happened in the writ petition when it was heard, the impact of the award was overturned. So
why? What did the court say?
The court says because in the writ where we're alleging certain violations on the part of the urban land development, it said since the authorities then did not have the power to grant you lease, so the writ is not maintainable. So that essentially interferes with whatever the arbitral award we got it. So against which we came up in appeal, because our contention was my writ is vis-a-vis in the inactions on the part of the government, where I was given a property to develop, to build a women's hostel. I have substantially constructed. The West Bengal Housing Board was the respondent, which has granted me the lease. And the West Bengal Housing Board was originally was granted lease by the Urban Land Sealing Department. So they cancelled it. Having cancelled that, we had filed this writ petition where we were agreed with the observations and also the decision-making process of the learned single judge. This writ appeal was admitted. There was an interim order passed in the original writ petition not to take any steps to dispossess me, and subsequently the can was disposed of, stating everything will be abided by the result of the appeal. So it is at this stage, because we were really suffering because we were not able to move it. I am being led by Mr. Bose, Your Lordship.
Have you filed paper books?
We have filed paper books. Everything is complete. The last order records as a last chance being adjourned. So that's there. I am being led by Mr. Bose, Your Lordship. We have also prepared a list.
Who is opposing you? Mr. Siddiqui.
Siddiqui is for the government. It's incorrectly recorded. We are for the appellate.
But for your lordship's convenience, we prepared a list of dates. Let me hand over. One.
The list of dates.
Well. এই সেম লিস্ট অফ ডেটস কি আমার কাছে আছে?
আমরা বলেছিলাম
না, ওরা 2000 থেকে আছে।
All hearing matters.
iPad-টা দে। Well, the issue is very simple, my lord. There was a connected arbitration proceeding, which I have succeeded. If I may just in gist tell your lordship briefly the facts, by then I'm sure the state will realize the matter has been called and it might be here. My lord, Ministry of Women and Child Development. My lord, there is a department, my lord, called the West Bengal Social Welfare Board. My lord, West Bengal Social Welfare Board, my lord, had initially was authorized to procure a land for the purpose of construction of a working women's hostel. Well, this all started in the year 1977. Well, this exercise failed, and well, the working women's hostel could not be set up because of lack of funds. Well, this situation continued, if your lordship will see the list of dates, till about the year 2000. We've given the details of why, and based on government records, which forms a part of the appeal paper book, that this is exactly what transpired between 1977 and till 2000, that no steps were taken. So thereafter, if your lordship will kindly see, the publication was made where I come into the picture. Lord, before that, if your lordship will also kindly make a note of the date, which is 9th of June 2000. Well, there was land was allotted in Salt Lake for construction of this women's hostel. Well, this was done to the respondent number 3. This would be your lordship serial number 12 of the list of dates. Well, thereafter, my lord, if your lordship will kindly take, well, based on a publication which was made in 2012, well, if your lordship will kindly take.
2006 notice was issued.
Yes, my lord.
For reallotment of the plot on lease.
No, my lord.
That is what you have written.
Which one, my lord? Which serial number?
Serial?
Yes, my lord, 12, yes.
Notice was issued by government
of West Bengal Urban Development Department to West Bengal Social Welfare Board, informing it that plots of land number such and such, measuring such and such were reallotted for a lease of 999 for the purpose of,
To whom reallotted?
this was to the board, to the Social Welfare Board.
That was granted in 77.
So, my lord, that if that final allotment was made by this notice in 2000.
Very good. Then what happened?
My lord, the possession, if your lordship will see the previous date, which is date number.
Now they published an advertisement.
Then this publication of advertisement comes.
On 17th of October 2012.
My lord. Now, my lord, if your lordship will see, my lord, this is where I come into the picture. An advertisement was published for construction of a multi-storied building on this particular land, which was allotted to the welfare board.
The new expression of interest.
My lord. And a letter of intent was issued in my favor, my lord, by the board. So, my lord, in terms of this letter of intent, I was required to construct this particular building where, my lord, a few floors would be dedicated for the women's hostel and the remaining floors will be given to me. And I will undertake this construction at my cost and expense. So this is what was awarded to me under the letter of intent based on a public advertisement. Now, my lord, if your lordship will kindly come to.
Please repeat what it was said, that you will construct the building.
I will construct the building and a few floors of the building will be dedicated to the working women's hostel.
And the
remaining will be for my commercial exploitation. Because I will be constructing the building at my cost and expenses. So that was my entitlement under the letter of intent and the understanding which was there between me and the state. Well, this was also done under the public-private partnership. Well, that if your lordship will kindly take one serial number 24. Well, this joint development agreement was entered into on a public-private partnership model. This, your lordship, is a part of the paper book as well. Now, my lord.
Now then possession was given to you.
Yes, possession.
What happened ultimately?
I started construction. I was in possession. I started construction. Now what had happened, my lord? If
They cancelled.
Yes. Now, my lord, no. Initially what happened? Now, my lord, everything started, my lord, in the year 2014. If your lordship will see, there was I wanted a approval for a FAR. At this stage, my lord, the central board accorded no objection to the project. Now, my lord, in 2016, if your lordship will see, there's a date of 25th of February 2016. My lord, serial number would be 34. Now, there was a letter which was issued by the board to the appellant, referring to a clause in the lease deed. It was alleged that the West Bengal board had entered into the development agreement with the appellant without the consent of the urban development department.
Yes.
And this, according to them, the person who gave me the contract and entered the development agreement with me.
That is the board.
That is the board. Now, board is nothing but.
Without permission.
Yes, I have granted this. Board is nothing but another arm of the state.
Then what happened?
Then what happened? They say that, if your lordship will kindly.
Money.
Yes.
30 lakhs.
Correct. Without consent, so there's a violation. So they say that the development agreement stands cancelled, refund of the caution money. So, my lord, there was an arbitration clause in the development agreement. So that part, the cancellation, I challenged the cancellation in a reference and I initiated arbitration proceedings. My lord, a retired judge of this honorable court was appointed as an arbitrator. Adjudication started and I succeeded in that adjudication process and an award was passed in my favor.
What was the award?
My lord?
What was the award?
Cancellation was, well, the cancellation of the lease, this cancellation which is there, well, the cancellation was held to be bad in law.
Cancellation of
the lease, of the development agreement.
Not lease.
No, not lease, not lease, not lease.
Was not a subject matter. Development.
9th of September 2013.
Lease was given by the state to the board, 999.
Now you come to when was the award delivered?
Well, this award was passed on, if you lordship kindly give me a moment. My lord, kindly see 31st of August 2017. Well, that would be item number 52 in the list of dates.
Yes.
Now, my lord, based on the state, the two arms of the state, now I am being sought to be dispossessed from my possession of the land which I was constructing. Now, my lord, once the arbitral tribunal and this award which has been passed in my favor has not been challenged either by the board or by the state. So whether this award under section 34 subsection 3 of the Arbitration Act is now reached a finality. No setting aside application has been filed. So my lord, there is an adjudication process which holds that the termination of the lease or the termination of the development agreement is bad in law. So that means my development agreement subsists. So I am required to construct. My lord, now starts the position which was the subject matter and my challenge in the writ. Now, my lord, board and now the state comes into the picture. State states that I'm going to take possession of this property.
Because I have not given permission
To grant this lease. No, to grant development. So the right to develop, state says now I will show your lordship the documents. Now, which was the subject matter of challenge before the writ court?
That state said this by which letter?
No, my lord, now state stand is a little different if your lordship will kindly see.
You filed the writ petition challenging what?
Challenging the action of the state to take back possession of the land from me.
By which letter they say that we are taking back possession, which you challenge, must have challenged.
Yes. But that is
challenging the arbitrary actions you preferred.
Yes,
did it.
yes.
What was that arbitrary action?
my lord, that is page, if your lordship will see, page 203. This is a letter of 3rd August 2017.
3rd August. 3rd August.
It's
2000,
of
prior to
July. My lord, there was a signboard which was put up in my property which said that this state is the owner of the property and they are proceeding to take possession.
3rd of August.
My lord,
2000?
this was in August 2017. There are photographs, and thereafter, if your lordship will kindly come to page 176. Page number. No. Page number. Actually, the list of dates I am carrying is giving this page number of this one. July 2017 and August 2017. Page.
Yes, sir.
182 তো তোমার চিঠি পেপার
My development agreement.
no.
This is
এইটা কোথায় July 2017 এটা well, if your lordship will kindly take once page 313.
Page 313.
Volume 2.
The paper.
Paper book. Yes, ma'am.
Page 313.
Yes, ma'am.
Why you are saying volume 2? We don't have paper.
Volume 3.
Yeah.
My lord, we have filed paper books. Yes, my lord.
Volume 2
No, George, have a paper book. Paper books have been filed pursuant to orders of court.
The application volume 1, volume 2.
No, my lord. But thereafter, pursuant.
Where is your paper? Where is your paper?
This is my paper book. These are my paper.
Huh? Have you submitted in office?
Absolutely.
Hello, office thing.
You have got it.
My lord.
313.
You will now. To
Diwan,
share
আরেকটা
for
paper
mark.
book that
We shall
George
mark
check.
it.
Yes,
We may mark it. And we also.
naturally, my lord, the paper book needs to be here. Needs to be here, my lord.
So most probably there is a communication gap in between department and such and such.
Possible.
So
My lord, may I just
Yes, then-
inquire from my advocate on record, was it filed in the department or in court?
You must have filed in the department.
in a department, in
Usually.
court we generally record order.
Correct. So then your lordship has to call for the paper books.
পেপার উপরে রিকুইজিশন করে ফাইলিং করেছে বলছে। Then what did the writ court say?
My lord, writ court by the impugned order, writ court has gone into the interplay between the award and the stand taken by the state, and has said that since the termination has been that without taking into consideration the final award, he said that I don't have any right in the land effectively.
Termination?
Considering the fact
That permission was not
correct,
given.
it says that since the permission was not given,
Yes.
well, the question of whether the termination was bad or good held by the tribunal is immaterial.
To go for damages against the board.
Well, damage, I am in possession, I am constructing
Your
at the building.
Mr. Bose,
I am in
you are
possession.
the person who gave it to you
Yes.
gave it illegally.
No, I am saying that the person,
Board gave it to you.
so the
Lease deed contains a clause that you have to give it with the permission of the state.
no, I am saying from the documents we've been able to establish that the government had noticed, knowledge, and had given permission. So this is the subsequent, till 2011, the stand of the government was different. In 2013, suddenly the stand of the government changed. This exercise,
How will you wriggle out of that clause, Mr. Bose?
the question is that if I show,
In the lease deed.
yes, yes,
Here, you lease deed, you read clause 8, I think. It is the formal
Your Lordship,
that no action can be taken without the prior permission of the state.
what I am saying, there are documents on record which substantiate permission
Show us
given by the state that for the
entered into an agreement with you.
for the purpose of construction of the hostel, and the fact that the state does not have fund, so the state is authorizing them to proceed. So on the basis of that, the publication was made, and it was in the public domain. So when a publication is made based on another, but the board is nothing but another arm of the state. So one arm of the state, which are both, my lord, state within the meaning of Article 12, one says, I have not given you permission to go and make the publication and give development right to somebody else. But if I need to show your lordship the
exact
documents.
reason, paragraph 25 of the judgment. That this is what we are saying. Para 25
The lordship is looking at the
of the order in
yes, but kindly give me a moment. Page 415.
internal page 16 of the order.
Internal page 16 of the order. Yes, my lord. Is your lordship at para 23?
25.
25. In this backdrop, this court is inclined to hold. My lord, this backdrop is what your lordship needs to consider, which is the subject matter of this backdrop. So under this backdrop, could such a conclusion be arrived at by the single judge?
The state will say we are not party to the development agreement. The terms and condition of that development agreement is not binding upon me.
No, my lord, I'll tell you, lordship. If your lordship, well, the sovereign cannot say that. This cannot be cannot be a stand of a state within the meaning of Article 12. The West Bengal, my lord, Social Welfare Board is nothing but an arm of the state. They are saying the Urban Development Department has given the land to the board. Why? For social welfare work. So this social welfare work is required to be done through another department, which is the Social Welfare Board. So you have given the land to the Social Welfare Board for the purpose of construction of women's hostel.
Kindly, you have been given that. Now you have to leave, Mr. Bose. Court has said that whatever expenditure you have incurred, you tell it to the board and they will pay it as a compensation.
Well, I am saying that.
Para 26. Court appreciates the loss suffered by you. Impertinent to mention that petitioners are shielded from suffering irreparable loss, which allowed refund of the caution money and security made by the petitioner, requested them to submit their claim for the expenditure incurred by them in respect of the project along with valid documents.
As your lordship is aware, my lord, the compensation damages is the alternative claim. So I am saying that this development agreement subsists.
You show us those documents.
Yes,
that
of
you
course
are-
I will. Of course. Well, otherwise, your lordship cannot come to that conclusion. I need to show your lordship each of the documents. So should the paper book come back?
But how many volumes of six?
There are 3 volumes of paper book.
No. This you filed stay application 2 volumes. All the documents are there.
All the documents. With the stay application.
But you
I
have
am not
prepared
aware.
yourself from the paper book. Na? Must have prepared yourself from the paper book.
Yes.
তাহলে আর কি করব?
So if your lordship wants, we can file fresh paper book as well.
We are saying
Very well. So if the requisition is made, very
We have extensively heard Mr. Bose, learned advocate appearing for the appellant. However, due to paucity of time, we will on 26 we finish it off.
Yes, 26th of February.
Formal order করতে হবে?
My lord, maybe come back, subject to your lordship's convenience, maybe come back on the 1st or the 2nd week, if possible.
Of March?
Of February.
To first, 2nd week, it won't be possible.
Very well. We'll come back on the 26th.
Supplementary list, you
Very,
come and
very.
keep yourself ready.
Absolutely.
Now you have to show us those documents.
Absolutely. So it would be fairly at the top, so it will be taken up. Very grateful.
I don't know. Bench change করলে
না আমার আছে আমি রেসপন্ডেন্ট স্যার আছে
আপনি সেদিকে
Sir, so, would it be your lordship pleasure that it is marked as a part-heard matter? We'll come back. It is here.
matter shall be treated as hard in part.
Grateful.
I appear for the Kolkata. Shamsad Mukherjee Kolkata Port Trust.
Item 20.
May it please the lordship, my lord. This is an appeal filed by the writ petitioner.
Paper book আছে নাকি?
Yes, my lord, we have filed, my lord, in compliance to my lord's order. এটা আমার?
Yes.
My lord, very short point. Before your lordships, my lord, take up my lord's brief. May I just take, my lord, 2 minutes time to give a summary of the case?
Pass year for the respondents.
Responsory respondent.
Yes.
My lord, I am a, my lord, staff of Shama Prasad Mukherjee Port. Now, my lord,
it is an allegation against me that while, my lord, I was leaving my office in a dockyard, there was my lord, a complaint made by X, who also claims to be my lord and my lord, supplying agent in the port. That, my lord, I have my lord, demanded a bribe, and on the following day I had accepted the same. While accepting the same, it is also a claim and allegation against me that I was red-handed caught by the CBI team. My lord, on this allegation, my lord, a criminal case under the Prevention of Corruption Act was made against me. Simultaneously, my lord, a departmental proceeding also, my lord, was initiated. I was initially suspended. Thereafter, that order was revoked. I was taken to, my lord, to office. Finally, my lord, my lord, I was directed to be dismissed from the service. Removal. I stand corrected, my lord. Removed from the service. I prefer an appeal. The appeal authority, my lord, didn't, my lord, adhere to my appeal. From the order of the disciplinary authority, I preferred review. That also did not succeed. Then, my lord, I prefer the writ application in a longest judgment.
You of the appellate
Authority in terms of this, my lord, so far as that's to the authority, my lord, they didn't consider it. I prefer the writ application before the learned single judge. In the longest judgment, my lord, upon hearing the parties, my writ also was dismissed. In the meantime, the additional fact is this: in the CBI court, the Prevention of Corruption Act, my lord, I was found not guilty upon deliberation of a full-fledged trial.
after removal.
After removal, the facts, my lord,
Brought it to the writ court.
I brought it to the writ court.
Being acquitted.
Lordship, by, my lord, by way of a contempt.
When was your review in connection with appeal dismissed?
That was dismissed prior.
Much early.
Much early. Even after, my lord,
After substantial period of time, you were acquitted.
not very substantial, my lord, sometimes. And, my lord, interesting fact is this, my lord, may I just put to, my lord, possibly lordships, my lord, may also require to hear me. After I got acquitted, I, my lord, forwarded that copy also to my authority, requested them to reconsider, because the facts part say would appear, my lord, the allegations made in, my lord, the Prevention Corruption Act before the CBI court and, my lord, before the disciplinary proceeding are, my lord, even if your lordship do not find that it's totally verbatim, but almost appear to be similar and identical. One difference, lordship will find that there is a pillion rider who had accompanied me and in whose bike, my lord, I had traveled in that particular dock passage. That is outside of dock. That is only a difference. Even the witnesses are all same.
Because to the order impugned.
Mild. Kindly comes to page 493. The third volume, my lord.
বিশাল বড় জমি।
যেখানে
No, the payment is rejected.
পুরোটাই পড়ো।
Yes, show us what is the wrong in this order. What are your points? Formulate your points. What are your grounds of challenge?
Milord kindly comes to Milord here, Milord, the first point is Milord, in case of a bribe, Milord, test to be applied is that of a criminal proceeding. Here, in a disciplinary proceeding, the two independent witnesses appeared contradictory to each other, who were brought by the CBI, Milord, in for foundation of the charge.
That point has been dealt with in the judgment.
Kindly. I mean, so far in addition,
That's the point, because a very lengthy judgment.
My
you
lord.
shorten yourself.
Milord,
You can go on for-
kindly comes to page 502, where my argument were dealt in. Para 18 onwards.
You have read that. You show that how your arguments were discounted by the judge.
Milord, kindly then comes to para 30, page 510. Or Milord, para 27 onwards.
Sir, please do not go on reading the entire
No.
text. You show us where is the infirmity. We are in judicial review.
Lordship. Milord, kindly comes to the findings of the learned judge.
This is my argument, and this is the wrong manner in which it has been dealt with. Show us that the infirmity in the order.
Milord,
Are you ready?
Yes, Milord, I'm ready. Milord, kindly comes to para 27. 27 to 30 here. Milord, my point was that the findings of EO are at best, Milord, collection of materials. Milord, kindly see how it were dealt in.
The collection of materials, it was the inquiry officer examined 10 witnesses, taken on record, petitioner has cross-examined them.
Here, my lord, this is some of the witness. I cross-examined almost every witness. And my lord, there was nothing on record that, my lord, any of the witness, particularly the independent witness and the pillion rider, said anything against me. Even thereafter, my lord,
Said that in your argument before the single judge.
my lord, kindly comes to my lord, subpara D and my lord, C at page 503.
D and
Subpara C and subpara D. And we also took the point that disciplinary authority mechanically in one sentence say that I follow whatever the inquiry officer has said. At that point, kindly see para F, same page. And here, my lord, the authority entirely proceeded on suspicions. Kindly see I, para 20. I'm sorry, my lord.
your argument was this has to be proved to the hilt. It is the test should be such.
Number one. Number two,
And
we
that
said
the order of the inquiry inquiry officer was mechanically agreed to by the DA. To show us what is the which witness you are wanting to show that he has pillion rider.
Yes.
Now no, your point C, D, F you are relying. CD, show us the corresponding paragraphs by which the single judge has dealt with. That is, I think, at page 521.
yes. My lord, kindly comes to para 44, page 519.
519, yes.
And my lord,
Yes, kindly come to 521. That was the answer to questions B and C.
yes.
Now you are showing us from page 527.
Yes.
Yes, what is the document?
Kindly comes to para 47. Here, my lord, kindly see page 520. The evidence on record that has been placed meticulously and in detail by the learned counsel for the petitioner clearly and sufficiently in
What you are saying is 519 para 44.
yes. 519 para 44. This, however, does not mean that a disciplinary authority in a quasi-judicial proceeding could pass a one-line order stating that he agrees with the findings of the inquiry officer and issue an order of punishment. This has not happened in the instant case. The disciplinary authority in his three-page order has clearly stated that he has applied his mind to the entire proceeding. He has discussed the proceedings briefly and has come to agree with the findings of the inquiry officer. The disciplinary authority has also commented upon the evidence on record to some extent. So this is the only thing, my lord, that the learned single judge has considered. This is therefore not a case where the disciplinary authority has mechanically relied upon the finding of the inquiry officer. Now, kindly pause here for a moment. Kindly see what the disciplinary authority has passed the order. Kindly comes to the order of the disciplinary authority at page 258.
Show us the evidence of that, what pillion rider you are saying.
Smile.
Or show us how it has been dealt with by the single judge. Where have you said? You see, where are your formulation of that ground that the evidence which is not proper? There was a pillion rider who said that you have not done so. Where from you are getting all these things?
My lord, kindly then comes to my lord, kindly comes to my lord, page 541. Ground number 7.
Was the discrepancy in the evidence which you are harping upon.
My lord, that is what I was trying to show, my lord.
But you have not even showed that what had been the finding of the judge to the evidence.
My lord, kindly comes to volume 1. Not volume 2, page 246.
Now, so your entire case is that the based on no evidence. Finding of the disciplinary authority is based on no evidence.
Show us that there was no evidence to that.
And none of the witnesses have supported the management.
My lord, kindly comes to the evidence at page 202, the pillion rider.
The case of no evidence, then question of interference arises. Or if there is some evidence which is totally contradictory and maligns the entire text, then question of interference in judicial review may at least happen. You have to show us that it is a case of no evidence from the evidence which is on record.
And it comes to my lord, page 202, the evidence of pillion rider.
Now, entire evidence cannot be read.
No, I will only show my lord evidence of 3 witnesses, the 2 independent witness and 1 the pillion rider. Kindly comes to page 202. All are management witness.
202.
202.
Yes.
My lord, here kindly see Sri Piyush Kumar Nag, Assistant National Insurance Officer, Record Clerk at the time of incident, MW, along with his AO, such and such, is also present. Now, he was examined. Now, kindly turns to what he was examined on the next page, page 203.
Who is Vishwanath Dutt?
Vishwanath Dutt, that is the petition, your lordship.
Petition. Yes, what you are showing, page 203.
Yes.
Yeah. What is that?
This is my lord examination.
Identification of document.
Yes. Now kindly comes to page 204.
Yes.
Kindly see question number 5.
Yes. Was he? He was an assistant of the company.
He was the pillion rider. whose bike, my lord, who accompanied me, my lord, who was there, my lord, in whose bike, my lord, I was crossing that particular area
And you were intercepted by CBI
at the same
officials,
point of time.
and your hand, that litmus test was done.
That was the allegation.
Allegation. Why the test was not done?
My lord, before the CBI,
So that you have disapproved which evidence, which portion of the evidence disapproves your test to that effect? That report has been a part of the inquiry. That was the charge against you.
my lord, Mary.
This is a case not where the honorable single judge in principle accepts my argument of the writ petitioner. Please come to not paragraph.
According to you.
No, that's why whenever we make a statement in court, it's always in the form of a submission. And that goes without a writer.
Yes.
At best, it can be shown that Piyush Kumar Nath has not supported the management case.
But I just not take it, Lordship, not to internal page 12 of the judgment.
Again, we'll go back to the judgment.
Only not three or four paragraphs. Your Lordships,
Yeah, just now.
exercise of jurisdiction is to test the validity of the honorable single judge's order.
Yes. Page?
But internal page 12, paragraph 23.
So what is the page number of the order? Yes.
Paper book page number.
18th of April 24.
It's running page 507.
507. Yes.
Please come to the last caption on that page, the questions that need to be addressed. It has a broad caption. So the court frames the questions to be addressed by you. The questions to be addressed by this court are threefold.
Yeah, we have seen that.
Whether acquittal, whether the degree of proof to be applied in a domestic inquiry, whether the charges are akin to criminal proceedings, that is taking of a bribe, whether the disciplinary and expeditious authority are required to give detailed reason or any reasons at all when the findings of the inquiry report are being agreed upon. But please come to the finding of the honorable single judge apropos the first issue. Please come to paragraph 71 of the judgment. Page number 2. At 532.
71.
My lord.
Yes.
It follows from the above that there cannot be any straitjacket ipso facto consequence of extinguishment of a charge on a domestic inquiry consequent upon acquittal in the criminal proceeding. It must be essentially seen as to whether such acquittal was not proved or disproved. So that's the finding of the honorable, or the answer of the honorable single judge apropos the first issue.
Ipso facto, it will not prove or disprove. Yes, there is no
So
problem.
his lordship makes a distinction between not proved and disproved.
Yes.
Number having considered the judgment on 29 number so and so, although not placed by the counsel for the petitioner at the of the sessions court in the instant case in special case number so and so arising out of RC case number 30 of 2010, this court is of the view that the findings of the criminal court in its entire judgment can at best indicate that the charges against the petitioner were not proved. They cannot be characterized as having been disproved or extinguished in the eyes of the reasonable and prudent man. It is therefore a case where the charge in the criminal case is neither proved nor disproved.
Yes, His Lordship meant to say that this non-proof cannot be characterized as having been disproved or extinguished.
Not, the issue framed was whether this will have a binding efficacy on the departmental proceedings.
All right. Yes, next.
Not if, not kindly recollects not the provisions of the Indian Evidence Act. But it does not make a distinction. It does not make a distinction of this nature.
Section 3.
Section 3.
Yes.
Is proved and not proved. There is a distinction.
Yes, please come to the.
Hence, it is used that
Not proved, a fact is not to be proved when it is neither proved nor disproved. Now, proved.
You better go to the definition of proof and disproof.
Yes, proved and disproved.
The fact is
Proved, a fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists.
Now, disproved is not exist.
A fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition it does not exist.
That means when a court held that fact is proved, that means exist. Right? When a court says fact disproved, that means it does not
exist. Does not exist.
But here, in general cases, acquittal is for want of evidence, right? Or prosecution has failed to prove.
Failed to prove.
Court is not saying that whether there was a fact or not.
So, not the court does not say whether the fact exists or not. The court says the charge is not proved.
Yes. The prosecution has failed
to prove the charge.
Yes.
Yes.
Now, there comes the test of the similarity of the charges and the equivalence of the evidence. But this is propounded by judicial pronouncements.
Why should we go into the evidence? Why?
We're not required to be gone into.
Yes.
Now, there was similarity of evidence except for the pillion rider. All witnesses in the criminal proceedings were same as in the departmental proceedings except the pillion rider. And the pillion rider was not declared to be a hostile witness. He said that I was not there.
He did not depose in
Against me.
No, in the criminal.
No, he was only the only exception was the pillion rider in the departmental proceeding.
Now the pillion rider says that I have not seen.
And not the logic was, if somebody would have to take a bribe, why should he keep a witness with him? Unknown person with him as a pillion rider.
That we cannot dwell in. Question is, then how do you disprove the fact of the test which was conducted, the chemical test which was conducted?
There are evidence which can be gone into. If your lordships want to go into this issue, there are reasons why this should not be weighed at all.
Show us
yes.
Why we should not.
But I just complete this first issue answer and then come back to
of those facts. Why should we consider that to be disproved?
Had your lordships been deciding the criminal appeal, I would have taken your lordship through the other angle as well.
Yes, complete it.
Paragraph 73. In the backdrop of the aforesaid discussion, this court is of the view that the acquittal of the petitioner in the criminal proceedings would not negate the evidence in the inquiry and the detailed findings of the inquiry officer, which this court has very carefully been taken through by learned counsel for the petitioner. The answer to question A above would therefore be as above and against the petitioner.
Question A is
whether it is binding. Whether it is binding. But principally in paragraph 71, the court holds that charge in a departmental proceeding may be extinguished depending on whether acquittal was on proved or disapproval.
Proceedings.
Next week. But the inquiry report and that DA's finding both.
Come on the next day, Mr. We have extensively heard Mr. Majumdar that if you record the
Subject to what my learned senior friend will say, Miller. 10th, Miller, subject to response.
Subject to the
Convenience of your
the
lordship.
court.
10th.
10th February is a 10th February. Extensive. No, hard Mr. Majumdar learned it. The matter for further consideration in the supplementary studies. Harding Butler. 10th April, 10th February. 10th month is
In বন্ধ আছে?
further consideration on 11th.
11th. না করলো না তবে তো হাড়ির পাড় হয়
কোথায় প্রমিত ভট্ট
কি হলো কেসটা
আইটেম নাম্বার 1
অরিজিনাল ও আজকে 4:30 না
original side also.
My lord, may I be permitted to mention one matter? My lord, the urgency is that.
Yes. Original side, yes. What?
Responded in this matter. We come back to my lordship for the previous.
Yes. What happened? Where is Mr. Bag?
Tell your lordship whether they are willing to withdraw the appeal or not, because otherwise, prima facie, your lordship's sort of opinion.
Where is Mr. Bag?
Becoming fractious. I do not find them here. It's the order, 18th order Pursuant to that, after that, many other orders were passed, it has been acted upon. Your Lordship will remember the facts. Special officers report.
Which is special officer?
Taken exception to the report of the trial court also.
His juniors are also not here. But he is here. Dismiss for this.
Yes. Not this kindly do that.
Again, they will come with an application for restoration.
I will come again. After that order, there have been several orders passed. We have acted in terms of that order.
On 14th January 2024, when the matter was 25, when the matter was last taken up for hearing, Mr. Bagh, learned advocate representing the appellant, placed for an accommodation to avail necessary instruction. Prayed for an accommodation to avail necessary instruction. Stop. Accordingly, the
for one adjournment because they have not got the written instruction, but we'll withdraw it. That's my instruction, but we have not, since it's BCCL, we've still not received the written instruction. I'm only praying for a week's adjournment. We'll withdraw it, my lord. I'm only praying.
Yes, it's specially assigned before your lordships.
We keep it next. Yes,
My lord will kindly, my
can
lord,
you come back on
incorporate his
Friday?
prayer.
Friday, I'm not there, but Monday we can come back, my lord. I'm not there in town, my lord, on Friday.
No, the problem is the
Original site.
no, my brother won't be here.
I understand that, my lord. Yes. On the last day, my lord.
He's assigned to us. Then I have to
Lordship.
hear when we have heard with my brother.
My lord.
I have to hear with my
Indeed,
brother.
indeed,
But
my lord.
then the matter will be substantially different. I don't know if jurisdictional issue is involved.
I understand that, my lord. I'm in a difficulty because, my lord,
If you withdraw,
it'll be withdrawal without written instruction, my lord. That is the difficulty.
My lord, I should think not, subject to what my lord says. If my lords are pleased to record today that he is willing to withdraw, but he has not received any written instructions. So on that day, my lord.
But I can't be willing, my lord, without the written. That is the difficulty, my lord, I'm facing.
Making a statement or words to that effect.
My lord, then I'll be held accountable without a written instruction, my lord. That's the whole difficulty.
Or at least my lord writes he's awaiting a written instruction. Then whatever is
But
the
then
written
I'll
instruction.
be making that submission. That's the whole. That is why, my lord, I'm refraining from making that submission.
দেখে নাও না বাবা কোনো সময় আমরা আবার পাঠাট করেছি কি এইটার কানেকশনেই তো আরেকটা অ্যাপ্লিকেশন শুনেছিলাম না। ও ওটা অন্য ম্যাটারে, তাহলে দিয়ে দাও। Yes, tell us when you will come.
But any day, my lord, other than Friday, any day, my lord, I'll be there, my lord.
The next Wednesday করে দিও ওই 3:15 সময়।
Very deeply obliged, my lords.
But my lord, kindly record the submission made by him that he's awaiting written instructions. That is all. I'm not saying what
But
he
the
said.
only difficulty is, my lord, then I'll be held accountable for making that submission because I don't have that written instruction, my lord. I'm trying to, my lord.
That is what I'm asking your lordship to record, that he cannot make any submissions without written instructions.
Yes, that may be recorded.
That may be written.
Mr.
By our earlier order,
Yes, next. আরে আর কি হবে?
End of February.
Sure, end of February. ও এটা তাহলে ওই না 29 তারিখে শুধু ওইটা তো থাকে, এটা দিয়ে চলে যেতে হবে। এইটাকে তুমি ওই ফেব্রুয়ারি মাসের কার্তিক কোথায় ওই কার্তিক ওই
My lord, may I be permitted to mention one matter, my lord? My lord, this matter.
you are mentioning after the list has been called. What do you want?
My lord, this matter is relating to a assigned matter, lordship. to a bench, that is my lord and my lord Justice Rajabashu Chaudhary, and
Assigned to myself and Justice
Rajabashu.
Rajabashu. What, that partnership firm?
Yes, your
Lordship.
Yes, your lordship.
Your
My lord, there is
That
no.
substitution allowed?
No, your lordship. So, your lordship, the substitution is still pending before the suit court, and the order says it's returnable on 29th of January, your lordship. So, the same order.
29th of January.
Yes, your lordship. I have the orders, your lordship.
Very good. Then you mentioned before us in the second week of February. Let us see.
Lordship, there is medical emergency in this matter. The appellant is a kidney failure patient. Both the kidneys are damaged. He is going.
That was, madam, this bench cannot assemble prior to the last week of February. Try to understand. Moreover, this is with Justice Raja Bosu.
Yes, your lordship.
We would be in the circuit. We cannot fix the date also on your prayer. So please mention before us when we reassemble, when this bench reassemble. Yes.
Madam, may I permit to mention a specially assigned matter, madam?
Mention on that.